over the sea. Yeah. Oh, that's right. You probably don't have four, do you?
Remember. Sing 1, 2, 3, 4. Oh, okay.
You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant. Both sides ready to proceed. Yes, sir. Quickly, remember you were supposed to do that beforehand. Okay, who will be the defense's first witness?
Susan Mears, Your Honor.
Okay, let's return to jury. Okay, good morning, ladies and gentlemen of the jury. Did you heed all my previous admonitions? Okay, does the state recognize the presence of the jury? And does the defense?
Yes, sir, we do.
Okay, Mr. Baez, you may call your first witness for the day.
Yes, sir. The defense calls Susan Mears to the stand.
Do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Susan Mears, SUSAN, MEARS.
You may proceed.
May it please the court, Mr. Ain. Good morning, ladies and gentlemen. Good morning, Ms. Mears.
Good morning.
You were asked to bring in certain items of evidence so they could be introduced, correct?
Yes, sir.
And that includes Defense Exhibit CP, which is the Gatorade bottle,
Yes, sir.
and including the Defense CR, which would be, I guess, the cardboard which the syringe was in.
I don't actually know the contents originally of the bottle.
Okay.
I never opened it.
And you collected the items that were inside the bottle.
Yes, sir.
Okay. And the Disney bag.
Yes, sir.
And was that brought in as well?
Yes, sir.
That would be Defense CO. The Disney bag.
I don't know what exhibit number it is. I'm
Okay.
sorry.
May I approach the witness briefly, Judge?
Yes, sir.
Your Honor, I believe we have a stipulation that the items of evidence discussed by Dr. Rickenbach, the state has no objection to the introduction of those items.
I have no objection to the introduction of the ones that he's marked for identification. There was testimony about a syringe, and I don't believe that is contained within those packages.
Does she have this one? Do you have the syringe, or does the Orange County Sheriff's Office have it? Or
I have what I believe might be the syringe with me, yes.
okay. Can I have that? Your Honor, I believe there is no objection from the state to introduce this item into evidence as well. It hasn't been marked yet.
Let's get it marked so we know what we're talking about.
You need to sign. Okay.
Okay, would you hand them all to the clerk? I think you had some more that you had offered, but you had not handed to the clerk so she can receive those items in the evidence. And there being no objections from the state,
Correct.
they will be received in evidence as defense exhibits.
CP will become defense exhibit number 34. CR will become defense exhibit number 35. CO will become defense exhibit number 36. And DE will become defense exhibit number 37.
We have no further questions for Ms. Mears.
Cross-examination.
None.
Thank you, Ms. Mears. You may be excused. The defense may call their next witness.
We would call Stephen Shaw, Your Honor.
Raise your right hand, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
My name is Stephen Shaw, STEPHEN
You may proceed.
Good morning, Mr. Shaw.
Good morning.
You have since testified in this case, have you not?
I have, yes.
Okay. Your Honor, I would move to recertify Mr. Shaw as an expert in trace evidence, hair and fibers.
Okay. Mr. Shaw will be again accepted as an expert in those areas tendered.
Mr. Shaw, I'd like to show you items Defense Exhibit DC, DB, DA, CZ, CY, and CX. Mr. Shaw, do you recognize those photos?
I do recognize these.
Okay. And are they the photos taken of certain hairs that you have when you conducted your new study?
These are photographs of antemortem hairs stored in various conditions during my study.
And this is the study that you conducted after you were deposed in this case?
That's correct.
Okay. And when you say antemortem, you mean hairs taken from living people?
Correct. Hairs removed from living individuals.
I'd like for you to look at them and make sure that they are a fair and accurate representation of the photographs that you have taken of the hairs.
Yes, I recognize all these as photographs that I took during the research study.
And they are a fair and accurate representation of such?
Yes.
Okay. Your Honor, at this time, we would move these items into evidence.
As an objection, no appropriate.
You may.
Your Honor, at this time I would
Objection
move.
overruled.
Sorry.
Go ahead, Mr. Bass.
Yes, sir. At this time, we would move these items into evidence.
They will be received in evidence as defenses.
Now, Mr. Shaw, you had, I guess, many, many hairs in the study, right?
I did. I had 600 hairs collected from 15 living individuals.
Okay. And when you did this study, you, of course, were trying to see if the darkening band could be developed from living people.
Objection, leading.
Sustain. Rephrase the question.
Yes, sir. One of your goals was to see if you can duplicate any banding, correct?
Objection, leading.
Sustain. Rephrase the question.
What was the purpose of your study, sir?
The purpose of my study was really inspired, as I mentioned previously, by a thesis at John Jay College had presented, or I had come across. And during that study, they had taken hairs and submerged them in water, or put them in water as well as in soil. And they suggested additional studies be done to simulate these conditions and other conditions and compare them to hairs known to be removed from postmortem individuals. And so that's what I did. So I put hairs from living individuals in various conditions, under various conditions, trying to see if indeed I could get postmortem banding from these hairs.
And the person that suggested this was the person who was having their thesis done, correct?
That's correct.
Was it a master's thesis or a...
I believe it's a master's thesis.
Okay, so someone was trying to get their master's degree. They wrote a thesis. They came up with these new findings.
Objection, leading.
I have not finished
Just
the
a
question.
second. He hadn't finished the question.
They came...
Mr. Shaw, before you answer the question, wait for me to tell you to answer. Finish your question.
That's right.
They came up with these new findings, and you as a scientist kind of wanted to expand upon that. Would that be a fair characterization, or do you have another characterization?
Objection, leading, compound question.
Sustain this compound.
Rephrase
the question.
Yes, sir. Was the purpose of your study to expand on that prior study?
Yes, it was.
Now, the FBI has issues when they testify on postmortem loop banding, a exhibit. Do you recognize this exhibit, sir? Known as States N.O.
I do recognize that, yes.
And this is so you can demonstrate to the jury what postmortem banding looks like.
Yes, that's correct.
Okay. May I publish this to the jury, Judge?
Yes, you may.
Yes,
That was what?
States N.O.
N.O. That's identification. I mean, is it in evidence?
Judge, this was a demonstrative exhibit.
Okay.
It was marked for that purpose.
All right.
I have those photos. Your Honor, at this time I would like to publish to the jury States Evidence 123.
You may.
Sorry, not 123. 39. Excuse me.
You may.
I didn't count this vote. Defense Exhibit 39? You said States Exhibit 39.
Apologize then if I said that. Okay. Defense 39. Can you tell us what we're looking at here? Oh, sorry.
All right, it's there now.
Can everyone see that? Okay.
Counsel, expand it out so the witness can see the entire slide so he can identify it. There we go. Thank you.
Can you tell us what we're looking at, Mr. Shaw?
This is a hair that was stored in water for 17 days. So it's a hair collected from a living individual and then stored in water for 17 days. And this is one of the hairs, as was another approximately 193 hairs or 190 hairs approximately that were put into the test that I spoke about earlier in my previous testimony. And so this is one of the hairs that was initially identified as post-mortem banding by one of the examiners that took that test in their initial analysis.
And what they did was, they identified this area here as post-mortem root banding, or is that the area?
I would assume that's the area.
Okay. And they mistook it for something like in this photograph?
Objection. Counsel's use of the word they assumes a fact, not an evidence.
Sustained.
The examiner mistook the characteristics, which the characteristics appear similar in this photograph.
The examiner identified it as initially as post-mortem banding in their initial analysis.
Okay. And then, of course, another examiner had a different opinion.
That's correct. The other examiner did not identify it in their initial analysis, and when the two conferred with the confirmed results, they excluded this hair.
Okay. And the both examiners were aware that this was a study and what the hypothesis of the study was, correct?
Objection. Leading.
Sustained.
Were both of these examiners aware of the study, that it was a study?
Objection. Leading. Same question.
Sustained.
I think it's an open-ended question. What knowledge did the individuals have who examined this hair about what they were doing?
They knew that it was a test. They knew that I had been conducting a study on environmental exposure to hairs. But that's all they knew. They didn't know, obviously, the answers to the test. They didn't know if I had put any post-mortem actual hairs from deceased individuals into the test. So there's over 200 hairs that they examined. And in their initial analysis, each examiner correctly identified all the post-mortem banded hairs. Examiner 1 did identify one of the antemortem hairs as banded. Examiner 2 did identify a different antemortem hair as banded in their initial analysis. They then had a confirmed results answer sheet where they excluded those two antemortem hairs and included all the post-mortem banded hairs.
Now, was it presented to them? Well, let me rephrase that. They didn't think that this was an actual case that they were working on. They weren't given hair like it came in from evidence with an evidence package and things like that. They were fully aware that they were being tested.
That's correct. They knew it was a test.
Okay. Now I'd like to show you defense evidence 41. What are we looking at here, sir?
This is another antemortem hair, so another hair removed from a living individual submerged in water for 17 days. And this is the hair that examiner 2 initially identified as a banded hair in their initial analysis.
And if I can zoom in a little bit, I don't know if and you can observe through this photograph the darkening area here. Correct?
Correct.
And one of the examiners made a mistake with this one initially.
Yes, that's correct.
Has everyone had an opportunity? Okay. And they would be this photograph somewhat resembles some of the characteristics in these photographs, do they not?
I believe they're clearly different.
Okay. You do, but one of the examiners does not.
In their initial analysis, that's true, but through their discussion and additional examination, they excluded this hair as post-mortem banded.
And what are we looking at here, sir?
This is another hair removed from a living individual and stored or buried in potting soil for 100 days.
And is there some apparent decomposition beginning to appear on this hair?
Yes.
And where would that be demonstrated? Can you show that for us?
Yes, there's some striations in this area.
If you touch, okay, got it.
In this area here.
Got it. I'm going to now show you Defense 43. What are we looking at here?
This is a hair from a living individual buried in potting soil for approximately 100 days, or for 100 days.
And are there apparent decomposition beginning to start on this hair?
Yes, there is.
And can you show us where?
Yes, in this area here.
I'm going to now show you Defense 40. What are we looking at here?
That is another hair removed from a living individual that was submerged in water for 17 days.
Okay. And what's happening to it? What do you notice? Actually, let me rephrase that. Does it show any apparent decomposition?
There was some apparent decomposition in this hair as well.
Okay. And can you show us where?
In this area.
Okay. And what about the roots? Is that normal, the darkening there? Right over here?
It can be. It can be dark at that end from living individuals.
Okay. So that's normal. That has nothing to do with what you might consider post-mortem root banding.
That could be normal.
Okay. Oh, is there any other ongoing studies at the FBI on this type, on different environmental conditions for hair?
Oh, from living individuals?
Yes.
No, not that no, there's not.
Okay. So the only how many studies are you aware of that have been done on environmental conditions affecting hairs?
I'm aware of 3 studies.
3. And is this an ongoing area of study for hair scientists?
Yes, I am conducting research still in this area. It's a way to build on post-mortem banding and that discipline.
Okay. Now, sir, I'd like to direct you to your report that you wrote on January 27, 2009. Do you have that report with you?
I do. May I refer to it?
Yes.
we have the FBI lab number and the shooting of the exhibit so that I can find it.
08121 3001. Q number 59, 60, and 62 to 64, 66. Sure.
I don't see.
May I have a moment, Your Honor?
You may.
Mr. Ashton. May I unpublish this, Judge, the light
may.
from... Okay. Yeah, that's what I was... Is that correct? Okay. All right, Mr. Shaw, can you tell us what you were asked to do on this date, sir?
On in this report, I reported on hairs and fibers that were recovered from a hair mass, item identified to me as debris from the skull, as well as 3 pieces of duct tape.
Okay. And what were your findings?
Could we give the evidence numbers just so the record is clear which items we're talking about for the jury?
Q59, the hair mass, and then Q62. State's evidence 302. State's exhibit 271.
I believe which one is which? I think
271 is the hair mass.
the other one, 302, is the tape.
Correct. Can you tell us what your results were in those examinations, sir?
Yes, there were no hairs suitable for meaningful microscopical comparisons purposes found on the duct tape that were also microscopically dissimilar to the head hairs recovered from the hair mass. In other words, there were head hairs, Caucasian head hairs on the duct tape. All of these Caucasian head hairs were consistent with the hairs found in the hair mass.
And did you also recover textile fibers?
I did, yes.
And what was done with those?
Those were preserved on glass microscope slides.
Okay. Did you conduct any examinations on those textile fibers?
I did not.
Okay. I have no further questions for this witness.
Cross-examination.
Judge, just so no one is confused, all of the hairs on the tape were consistent with coming from the same person that the hair mass came from.
That's correct. All of the hairs suitable for comparison were consistent with that.
Now, the items that Mr. Baez showed you a moment ago, those are a small selection of some slides that you prepared for a PowerPoint that you discussed during your direct testimony but didn't show, correct?
Some of those, yes.
Now, did you do studies of hairs decomposing in cars and car trunks, correct?
That's correct.
But none of the photographs that Mr. Baez just showed you dealt with those hairs, did they?
That's correct.
This time, Your Honor, moving to Evidence States Exhibit QL, which is the PowerPoint that was discussed during his direct testimony during the State's case.
Okay.
Be received in evidence. The State's
Next exhibit is 305.
Yeah, just go ahead and close it. Thanks. While she's doing that, Mr. Shaw, would it be helpful in explaining the entirety of your study to utilize the PowerPoint to explain it to the jury?
Yes, sure.
Once she's done, Your Honor, we'd request permission to publish that.
You may.
Next exhibit is 323.
Thank you. Let me publish it to the witness and make sure that which one of the, should we start with, can you see the screen here?
I can now.
Okay.
Yes.
Should we start with figure 1? Which would be best to start with?
Yes.
All right, let's start with figure 1. All right, may I publish to the jury?
You may.
And Mr. Shaw, if you just want to let Mr. Perez know when to advance to the next slide, we'll go on to the next, kind of explain what we're looking at here and what it means.
Sure. As I said, there were 600 hairs from 15 living individuals used in this study.
Announce.
I need to amend that number 324. IQ is actually 3.
You may continue.
So this is a representation of some of those hairs, photographs taken before and after their exposure. So you can see these are hairs stored indoors on a windowsill for 233 days. You can see on the left-hand side is the hair before it was exposed, and on the right-hand side is the hair after it was exposed. So there is some apparent discoloration by sitting in the windowsill, it appears, but there's no apparent decomposition in these hairs.
And the basic difference in the appearance of these two hairs in the before, it's the different color hair. Is that correct?
Of the before.
The before pictures.
The before is the same hair as the after. So above is from one individual. The first two slides at the upper left-hand quadrant and upper right-hand quadrant, that is one individual, and it's the same hair. So it's the hair before exposure and the hair after exposure. In the lower half of this page, you have hair from a different individual, a single hair, and it's the same hair, the hair before it was exposed on the left-hand side and the hair after it was exposed on the right-hand side.
My point was that these two people obviously have different color hair, which is why the one of the hairs appears very light, the other darker.
That's correct.
Right. So in interpreting something like post-mortem banding or any kind of decomp, you have to take into account what color the hair was originally and then how it changed. Correct?
No, I don't think you need to know the color of the hair in order to identify it as post-mortem banding. You don't need to know what color it was beforehand.
Next slide.
Next slide, yes.
Next slide, please.
This is additional hairs stored on the dash of a vehicle. So this vehicle was parked in direct sunlight throughout the time period. So in this area, about 202 days in direct sunlight and not used during that time period. So you see the before is on the left-hand side, and the after is on the right-hand side.
Now, this vehicle sat unused, correct?
Correct.
And during what months was this?
This started in August and continued on for approximately 7 months, 6.7 months approximately.
And the hairs exposed in that regard, do they show anything, any changes due to decomposition?
No, there was no apparent decompositional changes in these hairs at all.
You ready for the next slide?
Yes, please.
Next slide, please. Okay. How about these?
These were hairs stored in the same vehicle, but in the trunk of that vehicle during the same time period and for the same number of days as I mentioned earlier. On the left-hand side, you have hairs before, and on the right-hand side, you have the hairs after their exposure. So there was no apparent decompositional changes here either.
And this was in a vehicle trunk for almost 7 months.
That's correct.
And you said this was was it outside in the sun or was it in the shade?
This vehicle was parked in a non-shaded area.
So direct sunlight.
Direct sunlight when there were sunny days.
For 7 months.
For approximately 7 months.
And no chain.
Correct.
Next slide, please.
These are hairs stored outdoors in a grass area, and this grass area was in an area where it could receive direct sunlight. And there was, as you can see in the upper half, the picture before and then the picture after, and you can see there is some change there, and some slight darkening and longitudinal striations at the proximal end or root end in the upper quadrant. In the lower half are additional hairs. Outdoors, what happened a lot was the roots were actually missing in many of the hairs. And it looked like there was apparent insect activity to the hairs lying outdoors. And so that's what it appears happened on the lower half of this page. There's the before on the left side and the after on the right side. You can see the root is completely missing.
Did you find some of that also in the Q59 hairs, the ones from the hair mass where the root was missing or badly decomposed?
There were some roots missing, yes.
Okay. Next slide.
Next slide, yes.
Next slide, please. All right.
This is a hair stored outdoors in a wooded area, so it did not receive direct sunlight. It was in a shaded area, and it was stored for approximately 14 days or 2 weeks. And there is some apparent decomposition, as you can see, at the root end, but no post-mortem banding.
Explain to the jury why it is, and I'm circling this darkened portions here, why is that not post-mortem root banding? From an expert's perspective, how do you exclude that as post-mortem root banding?
For post-mortem banding, you need to have an opaque band just above the roots. And so the root should be intact, at least mostly intact, and you should have a band above that root. In this case, the root itself appears to be decomposing. So the soft tissue of the root itself appears to be decomposing.
It takes a great deal of training to understand the subtle differences between various types of decomposition artifacts, doesn't it?
It does take some training, and also the microscope itself is a very useful tool, obviously, not just the photographs that you're seeing in two-dimensional, but using a microscope and focusing up and down on the hair, you can see where the hair begins to get its shape. So you can see that soft tissue of the root, and it doesn't, the hair doesn't have its shape at that point. But as you move up and just above the root, you can see that the hair is beginning to get its shape by focusing up and down on the microscope itself. You get more of a three-dimensional picture. And so that's what you're looking for. You're looking for that opaque band above the soft tissue of the root.
And is that one of the essential aspects of postmortem root banding, is the placement of the band in that very distinct area?
Yes, it is.
And without a three-dimensional stereo microscope, is it really possible to appreciate that distinction?
Not fully, no.
Okay, if we go on to the next slide.
This is another hair stored outdoors in a wooded area for 14 days. And there was, as you can see, the before shot and then the 3 after shots after that. So there was some apparent decomposition with this hair as well, but no postmortem banding.
Next slide, please.
These are additional hairs, or this is an additional hair stored outdoors in a grass area that did receive some direct sunlight for approximately 107 days. And you can see some apparent decomposition in that soft tissue area of the root.
That would be, if I'm circling this area here, is that what you're talking about?
Yes.
Right. But that's not postmortem root banding.
No.
Next slide, please.
This is an additional hair stored outdoors in a grass area again for 107 days. And you can see there is some apparent decomposition in this area. It's more, as you go up in magnification, you can see it's more actually longitudinal striations. So not really a band in that area, but more darkening and longitudinal stripes, if you will, in the hair.
And again, is that one of those subtle distinctions that with training and the right equipment you can appreciate?
Yes.
Next slide, please.
This is two additional hairs stored outdoors in a wooded area. Before on the left-hand side, after on the right-hand side. You can see in this particular hair the apparent decomposition in the soft tissue of the root. And in the lower quadrant, you can see the root itself appears really to sort of be shriveling in that particular, on this lower half quadrant.
Is that the portion I've just circled?
Yes.
Okay. Next slide, please.
This is a hair stored submerged in water for 17 days. And you can see there is some considerable change in the root, in the proximal ends. And so there's darkening in this area, but it is too far down into the root, into the soft tissue of the hair.
Is this one of the hairs that Mr. Byers was asking you about, the ones that one of the analysts originally thought was banding but then wasn't?
No, it's not.
This is a different one. So
yes.
This hair, even though it does show that darkening, both of the analysts excluded that as postmortem banding.
Correct.
All right, next slide, please. Let me get the annotation out of there. All right, go ahead.
This is an additional hair submerged in water for 100 days. And there are some longitudinal striations in this area here. And as you magnify and see it at high magnification, you can see striations in that area.
All right, next slide, please.
This is a hair submerged in water for 100 days. You can see some significant change in the root, in the size of the root itself, this soft tissue. And there is some darkening also in this area. And as you go up into magnification, you can see it's darkened, especially on the outside edges, but not an opaque band in that area.
Next slide, please.
This is a hair submerged in water for 100 days. And you can see some changes with this hair as well.
But not banding.
No postmortem banding.
Next slide.
This is hair submerged in water for 100 days. Some slight changes to those hairs, but no postmortem banding.
Next slide, please.
This is a hair buried in potting soil for 17 days. And you can see some pretty significant changes again in this soft tissue, but no postmortem banding was observed.
Now, this darkened area here, again, that's not postmortem banding.
No, it's
Even though
not.
it's a little dark. Next slide, please.
This is another hair buried in potting soil for 17 days. And again, a lot of decomposition as far as the soft tissue of the root. And you can see just how much of that root soft tissue is missing, but there's no postmortem banding there.
Next slide.
This is a hair buried in potting soil for 100 days. And again, the soft tissue decomposes or apparently decomposes, and giving you a darkened area at the end of the root.
But not banding.
But not banding.
Next slide.
Another hair buried in potting soil. Again, some changes at the root end, including some darkening and striations at this root end, but no postmortem banding.
All right, if we could go on to the next file. Pardon me. Let me, hold on one second. Let me just unpublish for a moment while we get that set up, just in case. Go ahead, figure 2. All right, tell us about this. This first slide, this is one of the photographs that Mr. Baez asked about on direct, correct?
It is, yes.
Okay. Explain to us why that isn't postmortem banding.
Yeah, for one thing, the band itself is much longer than it should be for postmortem banding. So the darkening itself is much longer. There's also very little to no tissue intact on the end of the root itself.
Now, again, looking at this under a 3D microscope with the ability to zoom in, can you better appreciate exactly where the root starts and ends and that evaluation?
Yeah, as far as where the soft tissue starts and ends, especially, it's much better appreciated using a microscope in 3-dimensional and focusing up and down.
But this hair was stored in water, right?
This hair was stored in water for 17 days.
This is not one of the hairs that was stored in a trunk or in a car.
That's correct.
Next slide, please. Is this one of the other ones that Mr. Baez asked you about?
Yes, this is the other hair that one of the examiners initially identified as postmortem banded.
Why is that not postmortem banding?
This one is too far down into the soft tissue of the hair.
So, where would postmortem banding be on this hair? If you can tell from the photograph, if you can't without the microscope, I understand.
You really can't, without the microscope, determine exactly where it would be, but it should be further up. You can see there. You can see a little bit of how the hair is changing its shape in this area and begins to get its shape here. At least it appears so in the photograph. But to really appreciate that, you do need a microscope.
And the difference between the importance of that difference is because the hair, in fact, changes at that period from being soft tissue to being hard. Is it keratin? Do I have that right?
It is right. It's not fully keratinized. The idea behind postmortem banding is that the follicle protects the soft tissue. So the soft tissue is further down into the follicle and it's protected. Then above where you see postmortem banding, the hair is completely keratinized. So it's not susceptible or as susceptible to decomposition. So what you get is this one localized area that is susceptible to decomposition. So you get this specific band.
So it's the interior is soft, so it's susceptible to decomposition, but the outside is hard. Did I understand you correctly?
No.
I'm sorry. Good.
No, the soft tissue, what happens is the hair grows, it continues to harden and develop as it grows and moves up the follicle. And just above where you see that band is where the hair appears to completely harden and become permanent and dead. Where you see the band is the hair is not completely formed, it's not completely hardened, it's not completely keratinized. Below that band, the soft tissue itself, the reason that it's thought not to decompose with what we see in postmortem banding is because it's further down into the follicle and better protected.
All right. Next slide, please. Clear the annotation. All right. Tell us about this one.
This is a hair removed from postmortem from a cadaver stored outside on the ground surface. And so the banded area is here. This is one of the hairs used in the test.
And that is what you look for under, again, with the aid of the 3D microscope of postmortem banding.
That's correct.
Next slide, please.
This is another hair that was used in the test. This is removed postmortem from cadaver stored outside on the ground.
Now, this does appear to have a bit of a striation going farther into the root. Why does that not exclude it as postmortem banding?
Because you still have a very distinct area where the hair is banded, just above the soft tissue.
So that's what you're looking for.
Yes.
Next slide, please.
This is another hair that was used in the test, removed postmortem from a cadaver stored inside a house.
Now, in addition to the postmortem banding, is there also other apparent decomposition of this hair?
I don't know that this is apparent decomposition. It could be just a dark area in the person's hair.
And again, is that something you can't determine without having it under the microscope, the ability to manipulate it, zoom in, zoom out, and really look at it?
Yeah, even with a microscope, I don't know that you could determine that was apparent decomposition. It depends. You may be able to, but it may also just be an artifact of that person's hair sample.
Next slide, please.
This is another hair removed postmortem from a cadaver stored in a vehicle.
All right. Next slide, please.
Another hair used in the test, removed postmortem from a cadaver stored inside of a house.
Next slide, please.
Another hair removed postmortem from a cadaver stored outside on the ground surface.
Next slide, please.
Another hair used in the test, removed postmortem from a cadaver stored outside on the ground surface.
Now, is each one of these hairs from a different cadaver, or there are multiple hairs from the same cadaver?
There's some hairs from. There were 5 cadavers used in this study, so I removed hairs from 5 different cadavers. So some of these are from the same cadaver.
All right. Next slide, please.
These are another hair removed postmortem from cadaver that was stored outside on the ground surface.
Right. Next slide, please.
Again, a hair used in this test, removed postmortem from cadaver stored outside on the ground surface.
Next slide, please.
This is another hair removed postmortem from a cadaver stored outside on the ground surface.
Next slide, please.
Another postmortem banded hair removed postmortem from a cadaver stored in a vehicle.
Next slide, please.
Another hair removed postmortem from cadaver stored inside a house, and these are all hairs that were used in the test.
All right. And these are all evidences of what happens to they're evidence of what we call postmortem root banding.
Yes.
All right. I believe we have perhaps one other slide. Or one other set of slides. All right. Okay, again, these are examples, again, of the hairs from living people that were stored under various conditions and what you see.
Right.
Take us through it.
Yes, and this is hair that we discussed earlier. There's apparent decomposition submerged in water, but not postmortem
But
banding.
not banding. Okay. Is there another slide? Is this the only one?
This again is one of the hairs that we discussed earlier, buried in potting soil for 100 days.
And again, we see some changes, but not banding.
Correct.
Next. Yeah, Error actually worked for us on that one. Again, the condition is indicated in the slide. Some changes, but not banding.
Correct.
Next slide. Let me get rid of the annotation. How about this one?
A hair removed from a living individual and buried in potting soil for 100 days. So there is what may be changed in this area. I don't recall if I did identify that as change, but it appears there may be.
Some change, but certainly not banding.
Correct.
Next slide. End. Thank you. Of all the slides and all the various environmental conditions that you have exposed these hairs to, based on the slide presentation we've seen, did you have any hairs which were stored in a car, in a vehicle, that displayed any kind of darkening that might be similar to or mistaken for postmortem banding from
No.
vehicles?
No.
No further questions.
Redirect on those issues?
Mr. Shaw, the hairs that you tested in the trunk, did you put them in garbage?
No, I did not.
Did you have any that were in garbage?
No, I did not.
Okay. I know, if we can bring that up. I notice in your PowerPoint that all of the hairs taken from living people have the number of days before they were collected, correct?
That's correct.
Okay. Can you go through some slides? Keep going. Yeah. That's fine. Go back. But all of the slides that contain hairs that come from post-mortem individuals don't have any dates. Is that correct?
That's correct. That wasn't put on the slides themselves.
All right. Let's talk about these for a second. This hair that was outside of a house on the ground surface, how long was it there?
Can I refer to my notes?
Absolutely. Sure. Absolutely.
Okay, and I'm sorry, I can't see the slides.
Oh, I'm
so
sorry.
Not sure.
May I publish to the witness, Your Honor? May I also publish to the jury, Your Honor?
You may.
Did everyone see that? Okay, let's go back for a second. One slide. Okay. What I meant to say, I'm sorry, I apologize. The jury didn't have a chance to see what I was referring to. Every slide that you have from a live person says the exact days on each slide, correct?
That's correct.
And if we can go to the next slide. And every slide that you have from a deceased person does not have how many days when that hair was collected, correct?
That's correct.
Okay, let's start with this hair. How long was this hair outside on the ground surface?
That hair was placed in January the 27th of 04, and the hair was collected on March the 5th of 04.
So this is 3 months. More or less 3 months?
Approximately around 2.5 months.
Okay. And these were in Tennessee in the wintertime?
They were, yes.
Which are completely different environmental conditions than in this case, right?
I'm sorry?
The environmental conditions of which this hair was exposed to are completely different. Tennessee in the wintertime is much colder than Florida in the summertime, right?
I would expect so, yes.
Okay. So the environmental conditions that this hair was exposed to are completely different than that which would be in this case.
Right. The outside conditions, yes, are.
Okay, let's go to the next. And what about this hair?
This hair was placed on January the 27th of 04, and the hair was collected on February the 26th of 04, so approximately a month.
A month. And this was also Tennessee in the wintertime?
Yes.
Completely different than in this case. The conditions, the environmental conditions.
Complete different temperatures than I would expect in June, yes, in Florida.
Next one. Okay, we have this one stored inside a house. How long was this one in a house?
For approximately 1 month.
Okay. Do you know if they had heating in the house or air conditioning?
I don't.
Okay. And was this also in Tennessee in the wintertime?
Yes.
Okay. This one stored in a vehicle. How long was it in there?
Placed February the 28th of 05 and collected March the 16th of 05. So a little less than a month.
A little less than a month. Was this also in Tennessee in the wintertime?
Yes, it was.
And the car was outdoors. It wasn't inside a garage or anything, was it?
Correct. That's right.
Okay. Completely different environmental conditions than in this case.
Colder conditions than I would expect in the summer in Florida.
Okay. Next slide. Same thing with this one for the house?
Yes.
How
yes.
long?
Approximately 2 weeks.
Okay. And you don't know the conditions or the temperature of the house or anything like that?
No, I don't.
And of course, this was different environmental conditions than in this case.
Yes.
Okay. And this one, sir?
This hair was placed January 27th of 04 and collected February 18th of 04.
Okay, so approximately a month?
Couple weeks, 2 or 3 weeks.
Okay. And this was also Tennessee in the wintertime?
Yes, it was.
Completely different than this case?
Different environmental conditions than I would expect in the summer, yes.
Thank you, sir. Nice. What about this one?
This hair was stored in February for approximately 1 month.
Okay. Same environmental conditions, Tennessee in the wintertime?
That's correct.
Okay, next. And what about this one?
This hair was stored outside surface for 4 days.
Okay. And where was this? Tennessee in the wintertime as well?
Yes.
Okay. Next. What about this one?
This hair was stored in 04 for a little over a month in Tennessee.
Okay. And the next one? What about this one?
This hair was stored for approximately a month outside surface in Tennessee.
Okay. All right. Did your findings show that you got different reactions from the hairs based on different environmental conditions?
With the research study, yes.
Okay. And there is absolutely no way for you to replicate the exact environmental conditions that were the Q12 hair in this case.
Objection, leading.
Overruled.
I did not replicate all the conditions in this case. I'm not even aware of all the conditions in this case.
In fact, even if you were, you probably couldn't, right?
I don't understand.
If you knew more facts about this case, you still don't know how long that hair was there.
That's correct.
In fact, this hair could have been there for months.
Could have been, right.
And exposed to any number of environmental conditions.
Right, I don't know.
Okay. And, of course, one day you hope to be able to determine what exact indicators come from a deceased person. Do you not in your studies?
I'm not sure I understand that.
Sure, I'll rephrase the question. Do you, as a scientist, hope to one day be able to look at a hair and be able to determine that it came from a dead person?
Well, postmortem banding, it is a well-established science. It's based on examining hairs from living individuals, examining hairs from deceased individuals. It's based primarily on experience of examiners throughout our field. And so it is well established. The research is there to learn more. And so I wouldn't say I'm hoping to do anything. I'm just trying to learn more. And that's what this research was aimed at, gathering additional information.
But the science as it is right now is you cannot say that a specific hair, without knowing where it came from a dead person, correct?
We can't say that absolutely, right.
Okay. And you hope to one day, with all of your studies and the advancement of science, be able to determine that one day, right?
I wouldn't say I hope to do that, no. I just want to learn. We want to know as much information as we can about it. And whatever information that gives us, it makes us a better forensic scientist.
Wouldn't that knowledge assist you, though? I mean, wouldn't you like to know one day, looking at a hair and be able to say, okay, this indicates that this came from a dead person?
Not necessarily. I mean, if we were able to replicate it, I did try to replicate postmortem banding in this case. I mean, I put it in potting soil where I thought decomposition could be high. I put it in vehicles for a long period of time, intentionally parking them in direct sunlight, seeing if I could get postmortem banding. So my intentions were to put it in conditions that I thought were conducive to decomposition. So if we saw postmortem banding, then we would know, hey, under these certain conditions, we can get postmortem banding. But I didn't see that.
My question, sir, is not to diminish the importance of your study. I understand that. My question is you want to be able to learn more as a scientist and to be able to give definitive answers in the advancement with more experiments, correct?
Yes, we do want to learn more. We want to know as much about it as possible. But I wouldn't say that, I want to be able to say postmortem banding only comes from deceased individuals. That's not the goal. The goal is to learn more about postmortem banding.
And you would also like to learn more as to what environmental conditions create what indicators in hair, correct? I mean, you'd like to learn more. You don't want to just use your study in the thesis, the master's thesis, correct?
Sure. You want to continue to build on every discipline.
And perhaps one day the science will be sophisticated enough to be able to establish exactly what environmental conditions have what effects on an individual's hair, correct? Exactly.
As I said, I believe it is already well established. But yeah, we're trying to learn and gain additional information.
And this is well established through your experiments and through the experiments from the student getting her master's degree?
No, this is well established because of experience of examiners in our field. And again, that's examining hairs. You know, we deal with homicide cases routinely, and so we examine hairs from deceased individuals often.
My question, sir, relates to the environmental conditions.
Even in casework, we have hairs, you know, in cases and throughout different locations in cases that are exposed to environmental conditions. And I have yet, in my experience, found a hair that I've not been able to associate with postmortem banding that I've not been able to associate to a deceased individual.
And the examiner who misidentified one of these hairs, they can't make that statement in a court of law, can they?
Asked and answered, argumentative.
Sustained as the argumentative.
I have no further questions.
Any recrosses to those issues?
I do, briefly. The studies that you base your opinions on aren't just these hairs from Tennessee, correct?
That's correct.
I mean, you use these as an example, but the literature contains studies of hairs from many different areas of the country under many different environmental conditions. Isn't that correct?
Overruled.
There are publications with images of banding. But, you know, again, it's based also on experience and receiving cases all over the world, really.
And to this point, the only environmental condition that has consistently found to lead to postmortem banding is the attachment of the hair to a decomposing body. At this point, that's where the science is, correct?
That's correct.
No further questions.
Mr. Shaw, you did this study because you wanted to learn more, not because you had a little extra time on your hands, did you?
Objection, asked and answered.
Sustained.
Did you conduct this study because you wanted to learn more?
Objection, asked and answered.
Sustained.
I have no further questions.
May the witness be excused.
State's concerned. Yes.
Defense.
Yes, sir.
Thank you, Mr. Shaw. You may be excused.
Thank you, Your Honor.
Okay, members of the jury, 15-minute recess and special recess. Special, 20 minutes till hour.
Testing 1 2 1 2. Thank you.
You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed. Who will be the defense's next witness?
That would be Dr. Barry Logan.
Okay, let's return to jury. Okay, state recognized presence of jury. Defense.
Yes, Your Honor.
Okay, Ms. Sims, you may call your witness.
Your Honor, we would call Dr. Barry Logan.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help God?
I do.
My name is Dr. Barry Logan, spelled Logan.
May it please the Court?
You may proceed.
Thank you. Dr. Logan, can you tell us, please, your occupation?
I'm a forensic toxicologist and analytical chemist.
Okay, and you may need to get a little closer to the mic. I'm missing some of the words there.
Okay.
Could you repeat again what you do?
I'm a forensic toxicologist and analytical chemist.
All right. And can you give us the benefit of your education?
I have a bachelor's degree in chemistry and a PhD in forensic toxicology, both from the University of Glasgow in Scotland. I subsequently had postdoctoral experience at the University of Tennessee in Memphis, Tennessee.
You didn't get the accent, I take it.
No, this is not a Tennessee accent.
All right. How many years did you study at the University of Glasgow chemistry?
4 years.
And can you tell me whether or not you graduated with honors?
I did.
All right. And what board certifications do you hold?
I'm certified by the American Board of Forensic Toxicologists.
And can you describe that board for me, if you would?
It's a professional certification board that evaluates the education and experience qualifications of people who practice in the field. It determines if they're qualified to take an examination. If so, you take the examination, and if you pass the examination, you're certified as a board-certified toxicologist.
And what is a toxicologist?
A toxicologist is somebody who studies, toxicology in general is the study of drugs, poisons, chemicals, and their adverse effects on organisms. Forensic toxicology deals specifically with the medical legal consequences of a person's exposure or ingestion of drugs and chemicals.
Are you a forensic toxicologist?
Yes, I am.
All right. And how long have you practiced forensic toxicology?
Approximately 27 years.
All right. Are you an assistant professor within a university?
I have an appointment as a clinical assistant professor at the University of Washington.
All right. And can you tell me whether or not you have any background in gas chromatograph mass spectrometry?
I do.
And what is that background?
It was part of my training when I was in both undergraduate and graduate school. Subsequently, it's a technique that I use basically on a daily basis for the analysis of drugs and poisons in biological fluids and tissues in death investigation or human performance type casework.
All right. And approximately how many times have you conducted these tests over the last 27 years? Utilizing this equipment?
Thousands. Basically on a daily basis. I either, earlier in my career, performed these tests myself, or laterally, I review the data from those tests performed by other scientists in my laboratory.
All right. And can you tell me whether or not you teach or have taught gas chromatograph mass spectrometry?
I do. I currently teach it to students at Arcadia University in Philadelphia. I've also taught it at the University of Washington and the University of Tennessee.
All right. And with regard to, I'm going to call it GCMS, just to expedite things here. When you're using this equipment, are you testing tissue, fluids, and have you tested breath?
For gas chromatography, I've tested, yes, actually, tissues, fluid, and breath.
Okay. And are you familiar with cryotrapping?
Yes.
All right. And can you tell me your background with respect to cryotrapping?
It's a particular application of the technique called GCMS. It's a way to concentrate or amplify the contents of a sample to make them detectable.
All right. And what's your background in that?
When I was in graduate school, I participated in a project where we were examining chemicals that were present in automobile exhaust. So these chemicals were collected using a variety of different means, including collection on solvent traps and in mylar or bags. And the contents of the bags were then injected into the GCMS or introduced into the GCMS into the cryotrapping mechanism where the chemicals are condensed out and then introduced into the GCMS.
All right. And, Doctor, can you tell me, please, whether or not you're a reviewer for any professional journals? And if so, A, what is a reviewer, and B, what journals?
I am a reviewer for a number of journals, including Journal of Forensic Sciences, Journal of Analytical Toxicology, Analytical Chemistry. A reviewer is somebody who participates in the peer review process. So if somebody writes an article, does some research and writes a paper, and then submits it to the journal for publication, the editor of the journal sends that article out to people who practice in the field, who are familiar with the techniques, who provide some review and critique of it, either suggesting ways it could be improved or saying that it is suitable for publication. And based on the reviewer's input, the editor would decide whether or not to publish the article.
All right. And who is your current employer?
I work for a company called NMS Labs in Willow Grove, Pennsylvania.
And can you describe what you do for NMS Labs?
I'm the National Director of Forensic Services for NMS Labs. NMS Labs is one of the largest independent forensic laboratories in the United States. We do forensic testing for coroners, medical examiners, law enforcement agencies in all 50 states. My specific responsibilities as National Director of Forensic Services are to oversee the toxicologists, the professional board-certified toxicologists who review the data, review the results, work with our clients, answer client questions, help with the interpretation of results. I also participate in the process by which we determine what new tests we ought to develop to serve that client community, how the tests are to be validated and verified before they're put into production. I also consult on medical legal cases, either civil cases or criminal cases, where I'm asked to write a report and provide testimony. These are my principal responsibilities.
Do you also work with a nonprofit organization in your capacity as the director of the lab?
That's really a separate responsibility that I took on last year. I accepted a position as executive director of the Frederick Readers Family Renaissance Foundation, which is a educational nonprofit that specializes in forensic science education for both graduate students as well as to introduce high school students to forensic science.
All right, and you mentioned that you do consulting work. When you do consulting work and money is paid for the consulting work that you do, where does that money go? Does it go to you?
Well, it doesn't go to me personally, but it goes to the company.
What departments are there at the NMS lab?
There are about a dozen departments, and they're divided up based on the kinds of analytical methods that they use in the departments. So it would include things like a screening department, a department that tests for the presence of metals, a department that does confirmatory testing by liquid chromatography, a gas chromatography department. So they're all specialized based on the type of instruments they use or the type of testing that they're performing.
All right, and Doctor, are you an analytic chemist?
I am an analytical chemist, yes.
Okay, and how many articles have you published on analytical chemistry and toxicology?
Well, in total I've published 80 peer-reviewed articles that have been published in the medical and scientific literature. The majority of them have been on the topics of analytical toxicology or chemistry, but I wouldn't say they're all on that topic.
Can you break down for me what an analytical chemist does?
They apply their knowledge about the properties of chemical compounds and molecules to determine the best way to separate them from the background or from the sample they might be in, to make sure that they're properly identified, and then often to quantify how much of them is present. So it's a question of looking at what the compound is, understanding its chemistry, understanding how it can be separated from other similar compounds that it might be present with, and what kind of instrument would be most appropriate to measure it.
Okay, and can you tell me please what professional organizations you belong to?
I belong to the American Academy of Forensic Sciences, the Society of Forensic Toxicologists, the International Association of Forensic Toxicologists, the International Council on Alcohol, Drugs and Traffic Safety, National Safety Council's Committee on Alcohol and Other Drugs, the American Society of Crime Laboratory Directors, the Canadian Society of Forensic Sciences.
What is the American Academy of Forensic Sciences?
It's the largest professional organization in which forensic scientists in the United States participate. It has about 6,000 members in all disciplines, from chemistry to toxicology to biology to pathology, a number of different fields.
And what leadership roles have you served with regard to that organization?
I have served...
Your Honor, leadership roles do not go to qualifications, relevance.
I've served as the secretary and chair of the toxicology section. I've served as vice president of the organization, and I'm currently serving my second term as treasurer of the organization.
And are you familiar with the term scientific working group in the forensic science arena?
Yes.
And what does that mean?
These are groups that developed within this forensic science community, first of all unofficially, where people working in a particular discipline got together to determine where there was consensus in terms of the best methods to use for doing various kinds of forensic tests. The scientific working groups publish guidelines or standards that other laboratories can choose to follow. Over the last few years, the management of the scientific working groups has been taken over by the FBI, and they manage the activities of these there are over 20 scientific working groups now.
Okay. And can you tell me whether or not there is a scientific working group for decompositional odor analysis?
Objection, relevance.
Approach. Objection sustained. You may continue.
Thank you. Dr. Logan, can you tell me, please, your background and experience with regard to accreditations and certifications having to do with forensic laboratories?
Sure. I am board certified by the American Board of Forensic Toxicologists, so the term certification applies to individuals. That group and some other groups offer a process called accreditation for laboratories. So the process of accreditation is ensuring that the laboratory requires with a certain set of standards in terms of how they perform analysis, how they select and train their staff, how they document what they do. They're typically lengthy standards. I serve on the board of directors of the American Board of Forensic Toxicology, and I was involved in developing the standards for the accreditation of forensic toxicology laboratories. That would have been in the early 1990s. Subsequently, my laboratory became accredited by ABFT. The laboratory that I
object. I believe this is beyond the scope of the question, and also relevance. His laboratory's accreditation is not relevant to this matter.
Overruled at this point.
The laboratory that I currently work work for is also accredited by ABFT. So I participate in ensuring that the laboratory conforms with those standards. I meet with and am interviewed by auditors when they come to review the work of the laboratory. NMS Labs has a crime laboratory that performs drug testing and DNA analysis. That laboratory is accredited by a different organization called the American Society of Crime Laboratory Directors Laboratory Accreditation Board. That organization similarly has standards to which the laboratory must conform. These are enforced by the laboratory reporting its activities as well as on-site audits and inspections that take place every year. So that's the basis for my familiarity with the process of accreditation.
All right. And how many organizations have you been involved in that either certify or accredit labs?
Well, the ones that I've named, the American Board of Forensic Toxicology and the American Society of Crime Laboratory Directors.
All right. And are you involved in the auditing process, or have you been over the years?
Yes, I currently do participate in that inspection or audit process on behalf of ABFT. I've done that since the program was introduced. I also historically have performed audits on behalf of the Substance Abuse and Mental Health Services Administration of the federal government that certifies workplace drug testing laboratories or accredits workplace drug testing laboratories.
I lost you at the end part. You said you performed audits on other labs. Is that correct?
Yeah. Workplace drug testing, urine drug testing is regulated by the federal government, and there's an organization within the federal government called SAMHSA, stands for Substance Abuse and Mental Health Services Administration. So SAMHSA is the organization that's responsible for accrediting laboratories that do workplace drug testing. And I have served as an auditor for the SAMHSA laboratory accreditation process.
All right, Your Honor, at this time we would seek to offer Dr. Logan as an expert in analytical chemistry, toxicology, forensic science, and laboratory accreditation standards, gas chromatograph, mass spectrometry, and cryotrapping, those areas.
I would need to, I have no objection to the forensic toxicology. As to any others, I would need to put I.
You may.
Thank you. Okay, let me do it from here so I can view the list. Your expertise in analytical chemistry, what kind of analytical chemistry do you perform other than that related to toxicology?
Well, it's hard to separate the two. Analytical chemistry is the application of gas chromatography, mass spectrometry, other spectrometric techniques, the analysis of a wide range of chemicals and compounds in a variety of different materials.
But the question is, when was the last time you performed an examination of analytical chemistry for something other than toxicology?
Oh, that's part of my daily responsibilities. The crime laboratory that I oversee performs drug testing in non-toxicological specimens, so drugs that are collected or chemicals that are collected in the course of law enforcement investigations.
Well, under what circumstances? The question is, outside of toxicological examinations, what do you do in analytical chemistry that has nothing to do with toxicology? That's what I'm trying to find out. You seem to be telling me it's not all Go ahead.
Well, the analysis of drugs in evidence, well, toxicology deals with the examination of drugs in biological evidence. So that's toxicology.
Sure.
What I'm telling you is that I'm also responsible for the portion of the laboratory that conducts analytical chemistry on evidence that's not biological. So it would be unknown materials, mysterious white powders that are found in somebody's workplace or by law enforcement, drug evidence that's collected from people who are arrested for drug offenses.
So you would agree that your work is limited to either toxicology or supervising people that do analytical chemistry looking for drugs?
Not everything that we look for are drugs. Some of them are industrial chemicals, some of them are poisons, some of them are
but you don't do
inert
that part.
materials.
interrupt you, I apologize. But you don't do that. That's not the part of the lab you supervise. You supervise the toxicology section of the lab, don't you?
No, I do supervise the toxicologist, but I am also the director of the crime laboratory portion of NMS Labs.
Right. But your analytical chemistry is a very broad field, isn't it?
It is a broad field, yes.
It's a hugely broad field. Do you consider yourself an expert in every aspect of analytical chemistry?
No, I don't.
Right. So your experience is limited to that related to mainly toxicology. Is that correct?
I would say that my experience is mostly in the area of toxicology and in the techniques and methods that are used in toxicology examinations.
And your last experience with cryotrapping was as a graduate student, correct?
Yes, that's correct.
And that's over 20 years ago, is that correct?
Yes.
I need to go up and look, see what the other areas were, Judge. I apologize. There were quite a few. You are not an expert in all areas of forensic science, is that correct?
That's correct.
Your Honor, without spending too much time going back, this time I would object to any certification of expertise other than forensic toxicology. I believe his expertise is limited to that area.
Yes, ma'am.
This individual has a degree in chemistry with honors. And if I may also...
If it's going to be a long one, you need to come to the sidebar.
Well, if I could just ask him one question, that might...
You may.
Okay. What did you do in the capacity of being the Vice President of the American Academy of Forensic Sciences with regard to all the other fields?
I served on the board of directors of the organization. The American Academy of Forensic Sciences promotes scholarship, research, education in the field of forensic science. So it's a way to bring all of the disciplines together to look for commonalities in terms of standards, in terms of good practice and professional development and education.
That's all I have, Your Honor, with regard to that.
Okay. The witness will be accepted as an expert witness only in the area of forensic toxicology and permitted to render opinions in that area.
Doctor, as a forensic toxicologist, I believe you testified that you use gas chromatogram mass spectrometry in your lab. Is that correct?
Yes.
Okay. Now, in this particular case, can you tell me, please, what material you were provided with and you reviewed prior to coming here today and testify? What information were you given?
I was provided with some analytical records from the FBI laboratory with respect to the analysis of evidence collected from the trunk of Miss Anthony's vehicle. I was also provided with a report or a series of reports by scientists working at Oak Ridge National Laboratory that also related to the analysis of chemicals in evidence from the vehicle. I was provided with miscellaneous other documents related to the investigation of the case, including the autopsy records.
What about articles? What articles have you read prior to?
Objection. Bolstering.
Your Honor, I'm sorry.
Overrule at this point.
Yeah, I wasn't provided with any articles in the course of this case, but I did review a number of articles I had in my possession, as well as obtain some additional articles with respect to the particular chemicals that were analyzed in the course of the investigation.
Can you tell me whether or not you have reviewed the 2008 article authored by, in part, Dr. Arpad Voss with regard to decompositional odors.
I have.
And that would be odor analysis of decomposing buried remains in the Journal of Forensic Sciences.
I have viewed that article, yes.
Okay, I would like to talk to you about forensic labs for a moment. And, Your Honor, if I may have permission to use the tripod with the pad.
Yes.
Thank you. Dr. Logan. Is it on? Now, you've testified that your lab is a forensic lab, which is accredited by the American Society of Crime Lab Directors. I'm going to...
Your Honor, I have an objection. Reproach?
May. You may continue.
Thank you. Is this on? Yes.
Yes.
Dr. Logan, with regard to forensic labs, can you tell me, please, what the requirements are for the American Society of Crime Lab Directors?
Objection, relevance, as stated.
Sustain that question.
What is the difference between a forensic lab and a research lab?
A forensic laboratory is one that does analysis of evidence specifically for the purposes of it being presented in a court of law or before some kind of administrative review board. Certainly forensic laboratories do research. That helps them develop and improve and discover new ways of testing for things that haven't been detected or been able to be measured in the past. Research laboratories are typically academic laboratories whose mission is to simply discover new things where the application of them isn't necessarily clear of what the ultimate value will be. So they make discoveries that may have applications in medicine or in technology or in space travel or in any variety of different fields just based on discovering new properties of compounds or chemicals or objects.
Can you tell me, please, whether or not the research labs, particularly in this case, conducted proficiency testing?
Objection, basis of knowledge.
Sustain, establish a foundation.
Do you have any evidence, sir, that the Oak Ridge National Lab is a forensic lab and has been certified by the accredited American Society of Crime Lab Directors?
I have no evidence that it has been.
Do you have any evidence that the Oak Ridge National Lab has the quality control standards in place?
Objection, basis of knowledge.
Sustain.
What is a validation test in a laboratory setting?
When a laboratory develops a new test, before they start applying it to, well, particularly in a forensic context, before they start applying it to evidence, the test has to be fully characterized to find out what its level of sensitivity is, whether there are things that could interfere with it or cause a false positive result, whether there are limitations to the test that would prevent it from identifying what it was designed to test for, which we would call a false negative. Determining...
Let me object to the answer as applying a forensic lab standard relevance. He indicated specifically, particularly in a forensic context, which is not relevant in this case.
Overruled, he can finish answering the question.
And then you have to establish what kinds of material are suitable to apply the test to and show that different types of material are not going to cause interference or erroneous results when the test is performed.
Can you tell me, sir, after the review of the material that you have, whether or not validation testing was done in this case with the testing that was conducted at the Oak Ridge National Lab?
Objection, basis of knowledge.
Sustain, establish a foundation.
All right, I had asked you the documents that you've reviewed. Can you specifically identify them for me? The reports, the dates of the reports, the authors, etc.
I can if I refer to my records. Thank you. Well, I was provided with copies of laboratory notes from Oak Ridge National Laboratory made by Dr. Wise and Dr. Voss relative to the testing of the evidence in this case, as well as some additional materials that were done, that were tested in evaluating the method. I reviewed a document entitled Forensic Report, Orange County, Orlando, Florida, Final Report, dated April 28th, 2009, that summarizes the results of the analysis performed by the Oak Ridge National Laboratory. The report was authored by Dr. Voss, Dr. Wise, and Dr. Martin. I also reviewed deposition testimony by Dr. Voss and Dr. Wise.
When you say notes, are you talking about handwritten bench notes?
Yes, I am. Okay.
And can you describe what those are, what those purport to contain?
They're, if you like, a commentary on some of the things that happened while the analysis was being performed, when there were, when the test didn't work, or when something was wrong with the analysis, or when an unexpected result appeared. Sometimes they'll give a very broad summary of what the result of the test was, and they identify the samples that were tested during the course of the analysis.
And as a result of your review of the forensic report and the bench notes and the remainder of the material and the articles that you have indicated that you have reviewed, have you reached conclusions with regards to the procedures and methodologies utilized by Dr. Voss and Dr. Wise with regard to the experiment that resulted in their report of April 28th, 2009?
Objection. It's beyond his area of expertise in forensic toxicology.
Sustained.
When you reviewed the bench notes, can you tell me, please, or the report, anywhere in the material that you saw, whether or not there was evidence that there was validation studies that were performed?
Objection. May we approach the bench?
You may.
Thank you.
Dr. Logan, can you tell me, please, after reviewing the materials that we've just referenced, whether or not there were established, published protocols on how to conduct the testing that took place at Oak Ridge National Lab?
There were no formal protocols for the testing that was performed.
And what significance, if any, does that have with regard to results of such a test?
Well, the test itself, or the approach to the testing, has been described in published.
Objection to the question outside of the area of expertise and its effect on the results of this test. It's not a toxicological question.
Sustain.
If a test is conducted without established, published protocols, what kinds of problems can occur?
Well, if you don't have a written procedure for doing the test, there's no way to ensure that the test is going to be done the same way every time, whether the instrument is going to be set up correctly to do the test, whether the results that would be produced if the test was run on different days would be reproducible, whether there are things that could cause false positives or false negatives with the test if it's not done according to standard procedure. If somebody is unfamiliar with the process or two different people are doing the test, there's no way to ensure that they're both doing the test the same way. It's critical that for a reliable scientific test that you have a written procedure.
Let's use your field of
Objection
toxic.
and move to strike the witness's opinion about whether something is a reliable scientific test. It's beyond his area of expertise in toxicology.
Sustain. Approach the bench. You may continue.
Thank you. Dr. Logan, can you tell me, please, after reviewing the material, whether or not there was any documentation of protection against contamination with regard to the samples that were tested?
There's no evidence of what protection might have been taken with respect to preventing contamination.
And can you tell me, sir, in general terms, the purpose of having protection against contamination of samples that are tested, just in general terms?
Objection to the relevance of generalities not related to the facts of this case.
Sustain.
Can you tell me, please, whether or not there were quality assurance programs that were referenced or discussed or mentioned in any of the material that you reviewed?
Objection, again, same as at the bench, the absence of information is not proof of the negative. It's not existence. I just don't know if that's what I need to.
Oh, you can answer that question if you can.
I saw no evidence of any quality assurance that was relevant to the analysis.
What is quality assurance?
Quality assurance is the process by which you document the performance of the test, in which you challenge it with samples that have a known composition to ensure that you get the correct result, to test samples that are known not to contain the chemicals that you're interested in analyzing to make sure that they're not present by contamination or carryover in the course of the analysis. Quality assurance also consists of a process called proficiency testing, where the test is applied to a specimen which the operator of the test or the person performing the test doesn't know what the correct answer is. They perform it blind.
Objection beyond the scope of the question was about quality assurance laboratory procedures.
Stay.
Can you tell me, please, after reviewing the material that we just discussed, whether or not there was documentation of how control samples were obtained, the manner with which proper control samples should be obtained, etc.?
Objection, compound question.
Sustain, rephrase the question.
All right. Were proper controls discussed in terms of how they were obtained in this case in your material?
No.
And what is a control?
A control is a sample that contains a known amount of the chemicals that you're testing for. I'm
sorry, I object. This is beyond his area of expertise in toxicology. None of these questions involve toxicology. What is a proper...
Sustain, rephrase your question.
In toxicology, sir, do you utilize controls?
Yes.
And can you tell us what you mean when you say controls in terms of toxicology?
Objection to the relevance of toxicological controls in the context of this case, which does not involve toxicology.
Sustain.
When you reviewed the reports and the records and the other material that you referenced, did you render or do you have any opinions with regard to... Let me get my glasses here. Specifically, the bench notes as they discuss the manner with which the testing was performed on the samples, the control sample, the negative control, and the positive control.
I'm sorry, I didn't follow that question.
That's because it was a terrible question. Let me rephrase it. Do you have any opinions after reviewing this material whether or not there was anything in the bench notes that caused you any concern about the manner with which the test was conducted?
Objection. Outside of expertise in toxicology and attacking the other expert, as in the Cuban case, I think the court knows.
Sustain.
What is your understanding with regard to the blank samples, specifically page 73 of the bench notes?
Same objection outside of Aristides and the Cuban case.
Sustained.
Can you define what a blank sample is in your field in terms of using a blank sample for gas chromatograph mass spectrometry?
Yes. A blank sample is a sample that's known not to contain the chemicals or the analytes that you're trying to test for. It's to ensure that there's no contamination or interference with the test when you're applying it to evidence.
And what happens if a blank sample is run, but the computer is not changed to be consistent with the blank sample?
Relevance and outside of their expertise.
Your Honor,
It
may
deals
we,
with toxicology.
may we approach?
I permit him to answer the question.
I'm not sure I understand the question. It was about the computer?
Right, you're running a blank sample and you forget or you don't make changes on the computer, and then you have to do that and go back.
Your Honor, I objected also as a hypothetical, not based on the facts of this case.
Your Honor, may I respond? Or may we approach?
Yes, ma'am.
Can you tell me what the effect of running a blank sample but not changing the machine can have on the results?
Well, if you don't have the instrument set up or the machine set up appropriately to do the test, you won't get a reliable result.
And can you tell me the effect of not seeing a positive control when there should be a positive control? What is the significance of that?
Well, if you're performing a test on a sample that's known to contain a particular chemical or compound, and you perform the test and the compound isn't present, it tells you there's a problem either with the way the test was performed or the way the instrument was set up. And it's an example of why you ought to have a written protocol for doing the test.
Objection, not response to the question, and move to strike.
Sustained. Motion to strike granted.
All right, let me re-ask the question again, but ask you just to respond to the question, what is the significance of running a blank sample and the blank sample actually showing up as positive for a chemical when the chemical shouldn't be there?
If you're running a blank sample which is known not to contain the chemical that you're interested in testing for, and you get a result from your instrument that says it's present, then it's an indication of either contamination or a problem with the way the test was performed.
And what's the purpose of a blank sample in the first place?
It's to ensure that your test or technique doesn't give false positive results.
And what do you mean when you say false positive?
A false positive result is a result that's positive when the sample does not, in fact, contain what it is you're trying to test for.
All right. What is the significance of a closed valve essentially destroying or messing up a run? What does that mean?
I don't know that I think that question's too, I don't think I can answer the question the way it was asked.
All right. When you reviewed the reports and the materials, did you see any issues with valves being closed?
Yes.
Okay. And can you explain what you mean by that?
The bench notes that I reviewed from Oak Ridge indicated that sometimes when the test was run, the valves were not set in the appropriate position, and as a consequence, the result failed or gave a wrong result.
And what about triple sorbent tap freezing? Did that occur in this case?
Objection beyond the area of expertise of the witness.
Sustained.
What significance, if any, would it have to you if a lab were to be changing the technique that they were using in the middle of the experiment?
Objection beyond his area of expertise and relevance unless it applies to this laboratory.
I can explain.
Sustained. Rephrase the question.
When you reviewed the notes that were taken in this case, can you tell me specifically whether or not any of the techniques were changed in the middle of the experiment?
Yes.
Okay. And describe that for me if you would.
The conditions of the analysis were changed over the several weeks in which the various specimens were analyzed in order to try to correct problems with the operation of the instrument.
What significance, if any, does that have in terms of the use of the machines and the manner with which they are interpreted?
Objection beyond his area of expertise.
Sustained.
What does that mean to you, the statement that you gave? In terms,
Objection, same question.
Sustained.
when you run a standard to determine if the machine is reading the standard, can you tell me whether or not that it is done typically on the same day that you run the experiment? Or you run, that you run the sample?
Yes.
Why is that?
To ensure that you're testing the question sample or the evidence under the same conditions as you're testing the sample whose content is known.
Can you tell me, in this case, whether or not that occurred or did not occur?
It did not occur.
Do you know how many times?
Sorry, you just said it did not occur.
Okay. When you say did not occur, I need you to explain that. In other words, the standard's being run the same day as the sample?
I didn't count how many occasions that did not occur. There were specific instances in the notes where, or in the materials that I reviewed, where the evidence was tested on one date and the standards to ensure the proper functioning of the instrument were run days or weeks later.
Doctor, what is oleic acid?
Oleic acid is a fatty acid.
And can you tell me what compounds or what this can be found in?
Objection outside his area of expertise, toxicology.
Overrule at this point.
I'm sorry, your question was what?
Well, let's back up. Doctor, have you had an occasion to run tests in which there were fatty acids?
Yes.
How many times?
Fatty acids are prevalent in all kinds of biological materials, so they show up in the course of analyses that are done every day in toxicology laboratories.
So if you had to estimate how many times you engaged in testing wherein there was some form of fatty acid or fatty acids in the testing that you conducted, can you approximate for me?
It would be thousands of times.
Okay. Are you familiar with and have you engaged in testing in which the appearance of oleic acid occurred?
Yes.
What about palmitic acid?
Yes.
What about stearic acid?
Yes.
What about mysteric acid?
Myristic acid?
Myristic acid, I apologize.
Yes.
Okay. Can you tell me, please, whether or not you are aware of where what items can contain myristic acid?
Objection beyond his area of expertise, and it's beyond his area of expertise. He's a toxicologist.
Overrule at this point.
These fatty acids and many others occur in all kinds of biological materials, animal material, plant material, household products, foodstuffs.
When you said these, were you also referring to the oleic, the palmitic, and the stearic?
Yes.
As well as the myristic?
Yes.
You described some plant material. What other kinds of materials would you find this in? What are the kind of food products specifically?
It's present in dairy products, in meat products, cheese, butter, milk.
If you were to test an item that contained oleic acid, palmitic acid, myristic acid, and stearic acid, let's say a towel, a paper towel. As a toxicologist, what conclusion would you reach with regard to those 4 items?
Objection beyond his area of expertise. Those aren't toxicological substances.
Overrule on that basis.
You would conclude that those fatty acids were present in the paper towel.
Which can be caused, I believe you said, from a number of items, including cheese?
Yes.
And the percentage of, for example, which fatty acid may occur higher. Let's say you have all 4 in a particular substance. Can you tell me, please, whether or not you are familiar with the ratio of fatty acids in meat pizza?
Objection beyond his area of expertise.
Sustain until you establish a foundation.
Doctor, have you conducted any research to determine the relative ratio of these fatty acids with regard to pizza?
I reviewed published articles that describe the relative ratios of these fatty acids in foodstuffs, including pizza, yes.
And do you have an opinion or do you have an understanding as to what that ratio is?
Objection. I have multiple objections.
Yes. Approach. Okay, ladies and gentlemen of the jury, at this time we're going to recess for lunch. I'm going to ask you not to discuss this case among yourselves nor with anyone else. Please remember all of my other previous admonitions. We'll be in recess till 1:30. You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to continue.
State's ready.
All right. Let's have the witness back on the stand. Okay, let's return to jury.
Please be seated.
Okay, state recognized presence of jury.
Yes, Your Honor.
Does the defense?
Yes, Your Honor.
Okay, members of the jury, did you heed all of my previous admonitions during your recess? Okay, you may continue, Ms. Sims.
Thank you. I just have one final question. Dr. Logan, these 4 fatty acids that we've been talking about that can be found in food and biologic origin, etc. In this case, can you please tell me where those 4 fatty acids were found?
Objection. So where they're found? No objection. Sorry.
Questions?
They were found on a paper towel.
Thank you. That's all I have, Your Honor, at this time.
Okay. Cross-examination.
So is it your testimony that all 3 of these fatty acids found in combination are found in vegetable material?
Excuse me, Your Honor, I object. That states the testimony.
Overruled.
You're not saying that all 3 of these in combination are found in vegetable material, correct?
I'm not sure I understand your question. A combination of what?
Oleic, palmitic, stearic, and mysteric.
Are all of them found in...
Those aren't found in combination in vegetable materials, are they?
Yes, they are.
What vegetables?
In oily vegetables like palm oil.
Palm oil?
Yes.
All right. Not in cabbage, that type of vegetable.
I'm not aware that they're present in cabbage.
But they are also present in decomposing animal fat, correct?
Yes.
Excuse me, Your Honor, I object. Mr. Ashton has objected with regard...
He's answered the question. Untimely.
Is there a difference in the length of the carbon molecules in milk, cheese, and butter fat versus adipocera?
The same fatty acids are present in adipocere as are present in dairy products.
Are there a difference in the length of the carbon molecules in those two different circumstances?
Well, there are multiple fatty acids in adipocere and in dairy products. The 4 fatty acids that I've been discussed with me this morning are present in both. There are additional fatty acids that are also present in both.
Are the carbon chains in milk, cheese, and butter 4 to 10 carbons long, and the carbon chains in adipocere 14 to 18? 4 to 10 carbons long, and the carbon chains in adipocere are 14 to 18 carbons long. Is that true?
The carbon chains in oleic acid is 18 carbons long. The carbon chain in stearic acid is 16 carbons long. Carbon chain in palmitic acid is 18 carbons long, and the carbon chain in myristic acid is 14 carbons long. These 4 compounds are found in both adipocere and in dairy products. There are other fatty acids that have anywhere from 6 to in the 20s carbon chains. There's a mixture of them. They're complex mixtures.
Are there other compounds that are found in milk, cheese, and butter, particularly processed for human consumption, that are not found in adipocere?
Yes.
So upon chemical analysis, the difference can be determined.
If these compounds are tested for, yes.
Now, it is not unusual in any kind of examination of evidence in any context for there to be special challenges in looking at, in analyzing evidence on a GCMS. Isn't that true?
Is it unusual? It's not unusual for there to be special challenges. It can happen with any kind of evidence. It depends how complex or unusual it is.
Particularly with forensic samples.
Yes, I agree with that.
Forensic samples are rarely pure, so there's always challenges involved in those, correct?
Where you have standardized methodologies that are designed to accommodate the wide range of forensic samples that you're likely to encounter, you're going to have fewer challenges.
Are there situations where scientists are faced with challenges that are not in protocols?
Yes.
And what should a scientist do when faced with a challenge that's not in a protocol?
They should either develop a new protocol or adjust their protocol to accommodate the special challenges of that particular piece of evidence.
And that is an acceptable scientific procedure?
Yes.
Now, the protocols for the examination of decomposition odor are published in the Forensic Science Journal. Is that not correct?
The general principle is published in forensic science journals, yes, but not the detailed information as to exactly how the test is performed.
So the steps in the procedure are not published?
Correct.
So the Journal of Forensic Science does not give a step-by-step method of exactly how the samples are collected, how the triples over traps are desorbed, and how and at what settings it is run through the GCMS.
Well, with respect to those specific issues, some of that detail is contained in the published articles, yes.
Now, a blank is a sample of room air, in its sense of a air examination, is room air, which is run through a machine to determine whether there is any contaminants in the ambient air that should be of concern, correct?
That would be an example of a blank, yes.
Okay. And what should a scientist do when a blank shows some unexpected results?
They should investigate the cause of that, whether it's contamination or the instrument being improperly set up or operated, and ensure that and retest the sample to ensure that after these adjustments, it gives the appropriate result.
So you stop what you're doing, figure out what the problem is, correct it, and then run it again.
Yes.
When a scientist is faced with even something as simple as a human error of forgetting to close a valve, the proper procedure is to stop, correct the error, and start over, correct?
Yes.
And in both of those circumstances that you referenced in the bench notes of the work in this case, that is precisely what was done when these challenges were faced. Is that not correct?
The problem was diagnosed. The notes contained some detail about Dr. Wise's or Dr. Voss's opinion about why the test failed, and then what they did differently to ensure that it worked properly the next time.
And then they ran it again?
Yes.
And then reported the results of those tests?
Yes.
No further questions?
Redirect.
You were asked about challenges. What did you understand the word challenges to mean when you were answering the question?
Something that was unusual or unexpected about the sample that was being tested.
And what effect do challenges have on the reliability of the study?
Objection to an opinion of reliability in the abstract.
Excuse me, Your Honor, I'm objecting to speaking objections.
Okay. Objection sustained. Next question.
You were asked about protocols with regard to the detection of decompositional odors. Published protocols. Are there published protocols that you saw in any article or any of the material in terms of how to collect air from a trunk of a car?
No.
I didn't hear you.
No.
Are there published protocols on how to collect carpet samples from the trunk of a car? How much carpet? How thick it needs to be? Where to put it?
Compound question.
I'll stop it. Are there published protocols that you're aware of, sir, on how to collect carpet from the trunk of a car?
No.
What significance, if any, does that have to you in this case?
Objection. Opinion outside his area of expertise.
Sustained.
Dr. Logan, based on everything you've reviewed, including the report, the 2008 report that was referenced on cross-examination, all of the materials that you have, can you reproduce exactly this experiment that was conducted by Dr. Voss and Dr. Wise?
No.
And why is that?
Because there's a lot of detail missing, either from the laboratory, the bench notes, or from what was published in the Journal of Forensic Sciences about what the expected sensitivity of the test is, what other possible causes there could be for the patterns of chemicals that were identified in the test. So there would be no way for me to know whether the way I did the test was the same way that Oak Ridge had done the test.
Thank you, Your Honor.
Recross on those issues.
Dr. Logan, your laboratory couldn't do this test if you wanted to, could you?
Which test?
The test of the carpet samples in this case. Your laboratory doesn't do that type of test, does it?
We would be capable of doing that test.
All right. I'm going to show you States Exhibit 114 evidence, States Exhibit 143 in evidence, States Exhibit 322 in evidence, States Exhibit 323 in evidence. Have you ever seen any of those?
No.
If you had been sent one of those, could you have tested it?
Ladies and gentlemen of the jury, that's going to be a brief legal matter we need to take up outside of your presence. I will get back with you as soon as possible. All right. Mr. Ashton, your argument.
Yes, sir. I'm trying to find a case.
You may want to take a look at Hayes versus State, 660, 7th, 2nd, 257.
660,
660, 257, 7th, 2nd.
We'll do it. There's a case called Overton versus State that I'm trying to find the...
Which one?
Overton, Overton versus State. It's on my desk right now. Unfortunately, I don't have it with me. that is also relevant to the issue. I'm just trying to see if this is the right Overton. There's a number of different ones. Yes. Overton versus State, 801, Southern 2nd, 877.
801 what?
Southern 2nd, 877. It's Florida case 2001. And I'll look up the other case, 257. Case, sir. Once the court's done, I'll proceed with the argument.
Okay. I'm just trying to read Overton. You're talking about Head Note 18?
Yes. That discussion and the paragraphs above that lead into the issue.
On Hayes, read at Head Note 8.
Yes, sir.
Okay, I hear arguments from both sides.
Yes, sir. You want to go first?
Yes.
The state's position is that by defense counsel asking the question of this witness on redirect as to whether he could reproduce the results of the test, and his answer is no, I would submit that under Overton, that opens the door to the state's questioning the witness as to why he couldn't or whether he tried. So I would submit that the defense has kicked that door open by the question that was asked about the ability to reproduce the results of the test.
What about the opinion in Overton suggests that you could do that? Overton has to deal with some comments in closing argument where the defense tried to give the impression about one test and why they didn't do a second test?
Yes, sir. If you'll read the portion, I know you have, the portion leading up to the opinion, the reason for that is because the defense in their direct examination of their own witness, a chemist, discussed with the witness the issue of the existence of the essential, in this case was a spermicide, and whether I guess the state's argument was the existence of the spermicide was from some prior incident. And according to the case, during direct examination, the defense inquired whether the test conducted supported the state's theory that the spermicide was present in the bed sheet was simply a residue after the sheet had been washed. The witness testified that to make this determination would require the distribution of the chemical to be uniform throughout the sheet, and he would have recommended more testing because he could not conclude one way or the other. During cross-examination, he was allowed, the state was allowed to bring out that he had only tested one spot, and that when asked to make additional tests, that the defense attempted to prohibit him from doing so. I believe that in this case, just as in Overton, by the questions, the defense has opened the door to the issue of the ability of this witness to reproduce the results of the test, and therefore the question is permissible. In Hayes, as the court cited, Hayes stands for the basic proposition that the state cannot shift the burden to the defense unless they are asserting some defense that requires some burden, such as alibi, etc. Overton, I think, expands Hayes to acknowledge that sometimes the defense, by their questions, by their position they take in the case, can be so aggressive in their questioning as to, in fact, place a burden on themselves. And my submission would be that in this context, the defense's question went to that level of basically saying, can you reproduce the results? And it's fair game for me to discuss that with him.
And Ms. Singh?
Your Honor, I don't think it's even close. You were correct when you referenced footnote 8 in the Hayes case, allowing the prosecutor to elicit testimony over defense objection concerning failure of defense to request for testing was prejudicial and in error. My questions with regard to Dr. Logan had to do with the testing that was conducted in this case with regard to the protocol, the lack of standards. There's no way, as it was done in this case, it could be reproduced. That is completely different than opening the door to burden shifting. That would mean that defendants everywhere could not be asked any questions with regard to the science or reproducibility with regard to the state's witnesses, and I don't think that's what any of this case law stands for. It's clear that the experiment that was conducted in this case followed no protocols. There was no delineation as to how samples were obtained, why they were obtained, anything of that nature, and questioning that type of thing and asking if that particular experiment under those circumstances can be reproduced is not at all opening the door as suggested by the state. And we would move to also strike the comment and also ask for curative instructions. I think that this court is correct. Hayes is very clear. And the doctor answered when he asked, could you replicate this experiment? He said no. And the reason being, it wasn't clear what it was exactly or how it was done by Dr. Voss and Dr. Weiss.
Anything else from anyone else?
Not for the state, sir.
Okay. The Florida Supreme Court in Hayes versus State 667 2nd 257 addressed a proposition of law that basically deals with burden shifting, which shifts the burden of proof from the prosecution to the defendant. The court in Hayes, in an opinion authored by then Justice Overton, says as follows: The fourth error occurred when the trial court allowed the prosecutor to elicit testimony over defense objections concerning the failure of the defense to request testing of various pieces of scientific evidence. The state called as a witness an employee of the Broward County Sheriff's Office Crime Lab who testified concerning various pieces of physical evidence found at the scene of the murder, including clothing stained with blood. On cross-examination, the defense brought out the fact that the state had never requested a test of the blood stain. The apparent goal of this line of questioning was to cast doubt on the thoroughness of the state's investigation and to imply that a test of blood could have eliminated Hayes as a suspect. Then on redirect, the trial judge overruled a defense objection and allowed the state to inquire whether the defense had requested any testing of the blood stains. The witness replied that the defense had not asked the crime lab to test the blood stains and added that the lab had complied with such requests in the past for other defense attorneys. Similar comments were made by the prosecution in closing arguments concerning the failure of the defense to test hairs found at the scene of the murder. We find that the prosecutor's comments were prejudicial. In Jackson v. State 575 7 2nd 881 at page 188, a 1991 decision of the Florida Supreme Court, we found that the state had erred when the prosecutor commented on the defense failure to call a particular witness to testify. We explained, it is well settled that due process requires the state to prove every element of a crime beyond a reasonable doubt, and that a defendant has no obligation to present witnesses. Accordingly, the state cannot comment on a defendant's failure to produce evidence to refute an element of the crime, because doing so could erroneously lead the jury to believe that the defendant carried the burden of introducing evidence. The prosecutor's questions and statements in the instant case may have led the jury to believe that Hayes had an obligation to test the evidence found at the scene of the murder and to provide that the hair and blood samples did not match his own. Clearly, Hayes had no such obligation. In the case cited by the state of Florida, Overton v. State, 801 7 2nd 877, which is a 2001 decision of Florida Supreme Court. Just a second, lost my spot. Next, Overton suggests that the trial court erred in denying his motion for mistrial after the prosecutor made statements during the state's rebuttal closing argument that the defense had requested only one type of test, while the prosecution sought additional testing. According to Overton, the misleading argument suggested that the defense was hiding unfavorable evidence, and thus a mistrial was warranted. A motion for mistrial should be granted only where the error is so prejudicial as to vitiate the entire trial. goes on and talks about some things which are not necessarily applicable to the issue we're talking about. Based upon the evidence introduced at trial that the defense submitted one sample for testing and attempted to prevent Tragler from producing the additional confirmation tests for whatever reason, we conclude that the prosecutor's statement during rebuttal that the defense only requested one test and that the state sought a confirmatory testing was a proper comment on the evidence introduced at trial. Moreover, because defense counsel argued during closing that more testing was needed, we concluded the state should have been able to rebut that argument by noting that the defense only submitted one sample for testing and that the state sought to have more confirmatory testing performed. Accordingly, we do not conclude that the court abused its discretion in denying the motion for mistrial because the prosecutor's statement was a proper comment on the evidence and any potential error was not so prejudicial as to vitiate the entire trial. The defense's objection to the line of questioning is sustained in that it would violate due process by shifting the burden of proof to the defense. Now, earlier before we recessed for lunch, I asked the defense to read the case of Cuban versus State, 9/7, 3rd edition, 50, dealing with attacking the validity of another expert's opinion. This witness has not been qualified as an expert in the area of air sample analysis. If you recall the order that I entered during the Fry hearing, when the doctor testified in that Fry hearing, and what I said in my order about that was that he was not qualified to render an opinion in that area because what you produced at that time is only training and experience in that particular area had to deal with reading two articles, one by Dr. Strepanopoulos and by Dr. Vass. He is eminently qualified as a forensic toxicologist, has some knowledge in various areas of analytical chemistry. I would just tread very lightly in this particular area because while you did not, quote, open the door, it looks as though you're trying to get it cracked open. And Mr. Ashton looked like he's prepared to run a Mack truck through that door. And while we will not have any burden shifting, there's that adage, you cannot use the burden of proof. That is, you can't use it as a shield and then turn around and take it and use it as a club against the state. The proper line of, that's not my job. At this point, that line of questioning dealing with the cans at this point is sustained, subject to somebody opening the door. So,
Your Honor, under the circumstances with Mr. Ashton going up near the jury with the evidence, and it appeared somewhat, dramatic, we would request instructions to the jury, a curative instruction to the jury in light of the manner with which this came about, holding the bags of evidence and coming up and lining them up in front of the witness. We would just ask for a curative instruction to the jury in light of the manner.
Well, you didn't object to it. The only thing you objected to was burden shifting. Well, if I do that, the only thing that's going to do, Ms. Sims, is do an instant replay on that. If you're asking for instruction to disregard the last line of questioning, that would be the last question that was asked by Mr. Ashton, and say that the objection is sustained. I can do that, but
I have a feeling that would be just fine if we could remove those items and place them back on the table as well.
We can do that. Get to the microphone, Mr. Mason.
The quotation from the opinion you first read in this decision has exactly an appropriate curative instruction. That is, it is well settled in the law. The defense has no burden of proof. Remember that?
Yes, sir.
That sentence from the Supreme Court would be an appropriate curative instruction, in my opinion, and we request that.
So you're asking an instruction on the burden of proof. Okay.
As to which question is that related?
I've asked the court reporter to do it because she can probably pick it up faster than I can strolling back through this. For the last question, I asked her to find it, and I will do that, and let me.
Just a moment. Sorry. The question was, if you had been sent one of those, could you have tested it? At this point, Your Honor, that does not imply who could have sent him the item. So at this point, Your Honor, you've instructed me to go no further, and I shall. At this point, no curative instruction is necessary because it does not imply the defense's burden.
Out of abundance of caution, I think the curative instruction is necessary.
Now, I just want to make sure I understand the court correctly. Is the court indicating that I should go no further into his ability to do it or not do it, or simply not?
If you want to proffer that, let's go ahead and do it now. I think you do have a right since she raised the question. I don't think you can put the cans up there and ask him about his whether or not he could examine that. But I think the question that she asked was
whether he could reproduce the results.
Yeah.
Dr. Logan, in your laboratory, could you take a sample of this carpet, one of these cans, and put it in a Tedlar bag?
Could we be capable of doing that? Yes.
Could you heat it at 35 degrees centigrade for 48 hours, I believe is what the notes say was done?
Yes.
Could you extract an amount of air as indicated in the laboratory notes?
Yes.
Could you inject that into a GCMS with cryotrapping?
We do not have an instrument that is set up to do cryotrapping, but if we had such an instrument, we could do that.
could you set the instrument in accordance with the laboratory notes on the carpet sample item that was tested?
No.
Why not?
There is not sufficient information in Dr. Voss's published paper or in his laboratory notes to accomplish that.
What is absent from the laboratory notes as to the examination of the carpet sample from the can that you would need to set your machine in order to run it? I'm not talking about interpreting the results right now. I'm just talking about running it.
I would need to review his article,
So at this point, you're not sure?
That's correct.
All right. Well, if you need to take a moment to do that, aren't the settings for the machine in the bench notes?
No.
There's nothing about the temperature to be set, or that's not in the bench notes? No, Judge, I'll just withdraw it. It's not worth all this.
The question by the defense, in some ways, opens the door, but not to the point that this whole area is just like walking on quicksand.
That's fine, Judge. I'll withdraw it.
Well,
it would appear that
to the defense, when you're trying to impeach an expert, you cannot impeach the validity of the expert's opinion. You have to do that by showing another expert's conclusions were different. And what you don't have an expert that has examined this to show that his conclusions are different. And that's the problem with this whole line of questioning. Both sides read the following case. Network Publications found at 756 7 2nd 1228, a 2000 decision of the District Court of Appeals. We'll take a 10-minute recess. Okay, this is the instruction that I propose to give. It is a well-settled principle of law that the burden of proof is upon the state of Florida to prove every element of a crime beyond and to the exclusion of every reasonable doubt. The defendant has no obligation to prove or disprove anything. Any objections?
None from the state.
Okay, let's return to jury. State recognized presence of jury. Defense. Okay, ladies and gentlemen of the jury, I need to give you the following instruction. It is a well-settled principle of law that the burden of proof is upon the state of Florida to prove every element of the crime beyond and to the exclusion of every reasonable doubt. The defense has no obligation to prove or disprove anything. You may continue.
Sir, your laboratory does not perform air sample analysis, does it?
Correct.
And you have not been involved in an air sample analysis since you were a graduate student over 20 years ago. Isn't that true?
That's correct, yes.
No further questions.
Questions from the defense.
May the doctor be excused.
Yes, Your Honor.
Okay. Thank you, Dr. Logan.
Thank you.
The defense may call in next witness.
The defense calls CSI Jenny Welch.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes.
My name is Jennifer Welch, W-E-L-C-H.
You may proceed.
May it please the court. Good afternoon, Ms. Welch.
Good afternoon.
You're the crime scene investigator in charge of the recovery site off of Suburban Drive.
Yes, that's correct.
Okay. And in the recovery, numerous items were collected in evidence, over 300, correct?
Yes, that's correct.
Were there any socks or shoes recovered that belonged to Kaylee Marie Anthony?
There were no socks or shoes collected from the scene that I can recall.
Would your crime scene investigation then be consistent with the fact that Kaylee Marie Anthony did not have any shoes on or socks when she passed away?
Objection. Opinion outside the scope of any expertise she could possibly have.
Sustain.
I'll withdraw the question. No further questions.
Cross-examination? None. May the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
The defense may call in the next witness.
Yes, sir. The defense calls Cindy Anthony.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. So help you God. Thank you.
Cynthia Anthony, C-Y-N-T-H-I-A, Anthony, A-N-T-H-O-N-Y.
You may proceed.
Thank you, Your Honor. Good afternoon, Mrs. Anthony.
Good afternoon.
Ma'am, you also lived on, let me rephrase that. You used the computer at your home, correct?
Which one?
The desktop computer.
Yes.
And that is, where's the desktop computer located?
It's now our spare room. It used to be Lee's bedroom.
Okay. And the computer, everyone in the house has access to this computer?
Yes.
And who used the computer at the house?
Everybody. Anybody that was at the house that needed to use it, or even friends of Casey's used the computer.
Do you recall in March of 2008 you doing any types of searches for any items that might include chloroform?
Yes.
And could you explain to the ladies and gentlemen of the jury why you did that?
Well, I started looking at chlorophyll, and I was concerned about my smallest Yorkie. We have 2 Yorkie puppies. And the smallest one was having some issues where she was extremely tired all the time. And both of the dogs would eat the bamboo leaves out in the back. So I started looking up sources from the backyard that could potentially cause her to be more sleepy than it would affect the larger dog. And I started looking up chlorophyll, and then that prompted me to look up chloroform.
Okay, now, I don't understand how you could get those two mixed up.
Not getting them mixed up. If you look into chlorophyll, there's some bacteria associated with chlorophyll production, and looking up that, it comes from different species of plants that have red and brown coloring, and that prompted me to look up chlorophyll because some species of algae and seaweeds and stuff produce naturally chloroform.
Okay. And how do you know that you ran these searches in March of 2008?
Because I also ran a few other searches at the same time in March. There was a scare about using hand sanitizers around small children. There was an email that went around my employee at my work. One of my nurses had sent me an email knowing that, Kaylee was of age that she could be affected if we used hand sanitizer, and she got her hands on it. And that scare came out in March. And during the same time frame that I was looking up the issues about the dogs, I was looking up ingredients in the hand sanitizer, the alcohol, and then that prompted me to look up other things that we had in the house, like acetone, hydrogen peroxide, rubbing alcohol.
Did you run any other types of searches during that time frame that, and I'm specifically referring to March 2008, that might have to do with any types of injuries?
Yes, a good friend of mine was in a car accident and had multiple chest and head injuries and had a lot of blood loss, and I was looking up specific terminology that someone had asked me to look up. And at work, I don't have access to the regular internet. We had our own Gentiva internet, so I had to do those types of searches at home. I couldn't do it at work.
It's interesting you bring that up. We have your work records and evidence, and it shows that you work pretty much a regular schedule during that time period.
I took a day off during that time period, usually during the month of March. A couple important holidays fall in that time frame, and typically I would take certain holidays off because I had 6 weeks of vacation. And
why would your work schedule show that you were working?
Could have been an error if my supervisor filled out my time card in my absence, if it came on a day that our time cards would turn in.
I'm going to object to speculation.
Sustain.
Could your work schedule show that you're working and you actually be off? Has that? I'll rephrase it. Has that ever happened?
Yes, it has, and I'm also salaried, or I was salaried. So even if I put 4 hours in one day, I would mark down 8 because another day I might put in 12 or 14, and we were not allowed to show overtime. We were supposed to show 8 hours of work each day. Supervisors were not allowed to show any overtime for the corporate. We were instructed never to do that. So we were supposed to only show a 40-hour work week, and my normal day was a 9-hour day. So by the end of the week, I would always have overtime.
Okay. I'd like to show you States Evidence 79 and States Evidence 80. May I show these to the witness and publish the jury, Your Honor?
Yes. You showing which one now?
I'm showing States Evidence 79.
Thank you.
I don't know if... Well, I'll publish this in. Is there any way I could get rid of the glare a little bit? Okay, see. Mrs. Anthony, do you recognize this photograph?
I'm guessing that it looks like it could be the trunk of the Sunfire.
Well, I don't want you to guess, so I'm going to show you States 47. Actually, let me zoom out a little bit. That might help. Does that help you at all?
Yeah, I mean, it looks like the trunk of a car, and the car looks like it's white.
I'm going to show you another photograph. States Evidence 47. Is that the Pontiac Sunfire?
Yes.
And where was this car purchased?
Where?
Yeah, from who?
Oh my gosh, I know it was on West Colonial, one of the dealerships out there. I'm not sure what the name of the...
Who purchased the car?
George Knight did.
Okay. And when?
In 2000.
Okay. And then who drove the car?
Mainly George and Lee, but we purchased specifically for Lee.
Okay. And how long did Lee own the car?
We got it for him when he was a junior in high school in 2000, and then he drove it until I think 2005 when he got his Mustang. I think it was 2005 when he purchased his Mustang.
And after that, it was then passed along to Casey?
Pretty much, George or Casey would drive it. They had a car that they had. They had a Corolla. And once they sold the Corolla, then they drove that car.
I'm going to show you States Evidence 80, which is the trunk of the Pontiac Sunfire, a little bit of a close-up. Can you see if there is a stain in the trunk of that car?
There's a faint stain. Yes, I see it.
Okay. And have you seen that stain before?
Yes,
Where?
when we bought the car.
So it's your testimony that this stain was there when you bought the car?
There was a few little stains in the car when we bought the car, yes.
And when you saw the car again on July 15, 2008, and you sprayed the Febreze in there, did you see any other stains in addition to the ones that weren't there previously?
I think there was an indentation of a gas can temporarily.
Was it a cylinder type
Yes.
stain?
Yes.
Would you say that it would be consistent with this cylinder type?
Yes.
That would be the States 283, Your Honor.
Thank you.
Has everyone had a chance to look at it? If I can have just a moment, I'll double check.
Cross-examination.
Thank you, Your Honor. Mrs. Anthony, is it your testimony that despite the fact that your work records show that you worked on Monday, March 17th of 2008 and Friday, March 21st of 2008, that you were home between the hours of 1:43 p.m. and 1:55 p.m. on March 17th of 2008?
It's possible, yes.
Were you home on March 17th of 2008 between 1:43 and 1:55 p.m.?
If those computer entries were made, then I made them. I was home. I know I took some hours off. During that week was Casey's birthday and my anniversary, and I did go home early a couple days.
All right. Now you have to work at 7:30 to 5, typically?
My hours are whatever I make them to be. I had to be there at least from 8:30 to 5 o'clock, and then my hours got extended within 2 hours within 2 weeks after I started working, the hours got extended to 5:30. So when I signed up, it was from 8:30 to 5, but after I got hired, it was from 8:30 to 5:30. And I would always come a minimum of a half hour prior to and stay as long as I needed to.
All right. So it's your testimony today that it's possible that you were home on that day, even though your work records reflect something differently. That's correct?
Overruled.
Is that correct?
Yes.
All right. Even though your work records suggest or establish that you were working on March 21st of 2008, is it your testimony in front of this jury that you were home between 2:16 and 2:28 p.m.?
It's possible. I mean,
were you or weren't you?
That day,
Overruled.
the only thing that triggers that day for me is those computer entries. It was not a traumatic day for me like the last 3 years. So I can't tell you exactly what time I went home. If I had access to my work computer, I could tell you when I left that day.
Have you looked in the last 3 years to determine what time you went home on March 17th of 2008?
I have not been to work since July 15th of 2008. I never returned back to my employer.
Do they still exist?
Yes, they do.
If you wanted to, you could go and find out if, in fact, you left work on March 17th of 2008, even though your records reflect that you didn't.
No, I don't think so.
They won't let you in the door.
No, that's not the reason. The reason is because I had a working password and I was an employee, and only I would know through my emails what time I left. And no one had a password to my emails, and I'm sure all those things have been lost by now.
You're guessing.
No, I'm not guessing.
Let me ask you this. On Friday, March 20th...
You can allow the witness time to answer, complete their answer.
Ma'am, did you complete your answer?
No, I did not.
Complete your answer, ma'am.
We had several passwords to get into our computer, and I had at least 2 login passwords to my computer that only I had access to. It was against policy to give your passwords to even your supervisor. I also had a computer access password to my emails. And again, no one was allowed to get into my emails except me. And those computer passwords expire every 30 days. And without me being there to put in my old password to create a new one, no one would be able to get into my passwords.
Do you have knowledge as to whether or not your company backs up your emails?
I don't know if they would still have them 3 years from now, because the reason I say that is because our emails had a memory that only lasted so long, and it depended on how much was in there if we deleted them or not.
My question was, do you have knowledge as to whether or not your former employer backed up their emails on a regular basis?
Again, it would depend on the length of time that those emails were there. One office that I worked at, our company was nationwide. We were in 40-some states, and in each state there was many, many Gentiva locations. Ours was just one. And the capacity that each office could hold was a little bit. And every day we generated referrals, which came as emails for our patients, not counting the emails that I would get from other employees in the office and my staff. So there was only a capability that the computer could store those. So I do not believe that the company would still have the ones from 3 years ago. It would be virtually impossible to keep everybody's as a backup.
All right. You were aware of the fact that these computer searches were an issue as early as August or September of 2008, correct?
No, the first time I found out about the computer searches was with Detective Melich and Detective Allen coming to my house asking why Casey might perform those searches. And
When was that?
That was prior to Casey's arrest on check charges.
All right, so this would have been in September of 2008?
Whatever date that was, yes.
All right, I take it that you did not tell them that you made those searches, correct?
I did tell the law enforcement. In fact, I told you during my deposition in 2009 that I made those searches.
You told me at your deposition that you searched for chlorophyll, correct?
Yes.
And you spelled chlorophyll for me.
Yes.
You recall that?
Yes.
Do you recall denying that you made any searches for how to make chloroform?
I didn't look up how to make chloroform. I looked up chloroform.
Okay.
And I believe we talked
Did
about
you
it.
input into a Google search engine?
Excuse me, Mr. Burdick. I would ask that the witness be allowed to complete her answer before being interrupted by the prosecutor.
Did you finish answering your question?
I can't remember if she'd asked the question. And if she would read back what I said, then I might know if I had something else to say.
Okay. Madam Court Reporter, read back the last question and the last portion of Ms. Anthony's answer to her. And wait till she tells you to go ahead, Ms. Anthony.
Do you recall denying that you made any searches for how to make chloroform? Answer, I didn't look up how to make chloroform. I looked up chloroform.
Yes, I looked up chloroform, and when you look up chloroform, you don't have to look up how to make it. On there, it tells you what the chains are.
All right. You testified in the past that you looked up chlorophyll, correct?
Improper impeachment.
Overruled.
Correct?
Correct. At the same time, I looked up chloroform.
You suggested that the Google search engine asked you if you wanted to change the spelling of chlorophyll when you made this search, correct?
Correct.
Because you spelled chlorophyll wrong.
Correct.
Did you input the words into the Google search engine, how to make chloroform?
I don't recall putting in how to make chloroform, but I did Google search chloroform, and we talked about it in my deposition.
The question is, and it's a yes or no, did you type in to the search bar on Google how to make chloroform?
This question has been asked and answered twice.
Overruled.
Did you type those words into the search bar on Google?
I don't recall typing in how to make chloroform. I recall typing in the word chloroform.
Do you recall denying that you searched for self-defense?
Yes, I did not search for self-defense.
Household weapons?
I did not search for household weapons.
Neck breaking?
I did not search for neck breaking, but I do recall that there was a pop-up that was showing a YouTube regarding a skateboarder that was skateboarding on rails, like if you're going, like a turnstile type rail if you're going into some place in the skateboarder. And I recall it saying a neck breaking feat.
Is this something that you're recalling now that you've changed your medication since July of 2009?
Again, it's not...
Yes?
No, I recalled that at the time, but you didn't ask me about... I answered your question specifically at that time. But my memory is better than it was when I had my deposition in 2009.
Yes, ma'am. Did we cover whether or not you did a search for the word shovel?
No, I wouldn't need to look up the word shovel.
All right. On March 17th, did you look up the word inhalation?
Probably.
Do you know?
There were several searches that I did that day. I also searched regarding the injuries too.
Alcohol?
Yes, I said
acetone?
I already answered Mr. Bias to that, yes.
Peroxide?
Yes.
Hydrogen peroxide?
Yes.
Is this something that you've recalled since
No.
July of 2009, since your medication's been changed?
I recall doing that because of the email that I got regarding the effects if a child ingested hand sanitizer because of the alcohol content. That's why I looked up alcohol and I looked up those items, because it triggered me to look up other household items that we used near Kaylee. We painted her nails. I used acetone near her.
What search engine do you use?
Whatever's on the computer, whether it's Google or Yahoo.
What browser?
I'm not even sure what you're referring to.
Okay. When you turn that computer on, which profile do you use?
Our home computer, the desktop, we left on pretty much 100% of the time. It was rarely shut down. So usually if I had to go on, it was already on. All we had to do was just refresh it.
All right, so are you testifying you don't know which profile you used?
Profile regarding...
There are only 2 profiles on your computer. Do you know that?
Are you talking about my laptop or the desktop?
We're talking exclusively about the desktop. There's a user profile and there's a Casey profile. There's usually an icon when you turn it on and you pick one.
I don't recall having to do that on my desktop. On my laptop, yes, there was 2.
So on the desktop, you would not have entered a password, correct?
No, we did not have a password on our desktop.
Did you do searches for making weapons out of household products?
No.
Chloroform habit?
Chloroform habit?
Assumes facts not in evidence.
There's already been testimony about this, Your Honor. Chloroform habit?
I've never heard that come up before, no.
Chloro and the number 2? Was that you?
Chloro 2?
Mm-hmm.
I don't know. I know there's chlorophyll 1 and 2.
Okay. Were you on druglibrary.org?
Oh, all the time.
Instructables.com?
Don't know.
SciSpot.com/chloroform?
I don't know if it came up that way.
Were you on that website 84 times?
I was on it several times.
Were you on that website 84 times?
I don't know. They need to look up how many times I was on the chlorophyll website and compare it to the chloroform website.
Did you do 84 searches for the effects of chlorophyll on your animals?
I didn't do 84 searches of anything, but I don't know what my computer does while it's running.
Okay. In March of 2008, you did not have a MySpace account, correct?
No, I did not.
Did you have Facebook?
No, I did not.
If I may show and publish States 80 for identification. Your Honor?
You may.
Can you see that?
Yes, ma'am.
Where's this stain that was in the car when you purchased it in 2000?
The stain was somewhere up in here.
I'm sorry. Let me clear that because I think I took it away too fast. Tell us again.
The stain was up in the top section.
All right, near the letter B? Closer to the letter B than the letter A and the dryer sheet in the back.
Yes.
I have no other questions of Mrs. Anthony. Thank you, Your Honor.
Redirect.
Mrs. Anthony, I got a little confused. I wanted to make sure. The password protection was on your work computer, correct?
I had password protection on my work computer.
But as far as
But
your
not at
desktop
home.
at home, there's no password for that.
No.
And would you ever go on the computer after Casey would use it?
The computer was left on all the time. So a lot of times I would come home, Casey'd be on the computer, and I asked her if I could get on for a few minutes.
And all of this stuff about chlorophyll and chloroform, you had told the prosecutors about that back in 2009, did you not?
Yes, I did.
And this is nothing new.
No, it's not.
Is this anything new?
Sustain as to leading. Rephrase your question.
Is this testimony anything new?
No, sir. I did tell the detectives and I did tell the state's attorney's office about the searches. And they knew that I had searched for chlorophyll as well.
No further questions.
Any additional questions? May the witness stand down.
Yes, sir.
Thank you, ma'am. You may stand down. Defense may call the next witness.
How do we? I'll unpublish. Defense calls Sandra Kahn.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? This way, please.
Sandra Osborne, S-A-N-D-R-A-O-S-B-O-R-N-E.
Police court. Good afternoon, ma'am.
Sir,
I apologize. I referred to you as Sandra Kahn.
former name, that's quite all right.
Okay. And you prefer Osborne.
Yes, sir.
And you are a detective
Yes.
and also a computer expert.
A computer forensic examiner, yes, sir.
Your Honor, I would ask that the court re-recognize Ms. Osborne as an expert in digital forensics, as previously designated.
What's your next step?
No objection.
She will continue to be recognized as an expert in that field.
Ms. Osborne, who is the gentleman that followed you in today?
I'm going to object. It's relevant.
I would think it is relevant. The previous time that you testified, did you have another individual follow you in that time?
Same objection.
Ma'am, you were the first person to receive the Anthony's desktop computer,
That's correct.
and you then did a forensic examination of that computer?
You're referring to the Hewlett-Packard desktop?
Yes, I am.
Yes.
And one of the things that you did you were asked to run a keyword search for chloroform.
That's correct.
And subsequent to that, what you ended up doing is you found a hit, correct?
Correct.
And then after that, you identified a unallocated space, a deleted internet history. Did you not? Tell us what happened next.
You have to refine that for me.
Sure.
Next, after I found
After you found a hit for chloroform, what did you find next? What did you do next?
what I did with the search hit that I found for chloroform,
Correct.
I identified it as a deleted internet history file, and I turned that portion of data over to my Sergeant Kevin Stinger.
And did the two of you consult on this matter?
He is my supervisor and my mentor. He supervises everything I do, so I worked with him and he mentored me through the process, but he worked with that, with the other witness that you've heard from before, John Bradley. So yes, I watched his work do that, but I was not directly involved with that.
Prior to that, did you recover the internet history using a program called Net Analysis?
I did, yes.
And then what that is that's a competing, well, let me rephrase it. Is that a competing software to this new cashback software that Mr. Bradley testified about?
It's a different forensic tool that we use that is widely recognized in the computer forensics field. Its functionality is slightly different. It's a different tool. I don't know if I would say it's competing, but it's a different tool that we use. We use both.
But they both accomplish the same thing. They help you reconstruct or re-get the internet history that's deleted.
It allows us to view the internet history.
Okay. And what you do with that information is you then, I guess, put that on an Excel spreadsheet?
With the net analysis, I don't do the reporting typically with the net analysis reporting feature because sometimes a large history file will be hundreds and hundreds of printed pages. It's just easier to export it out to an Excel spreadsheet so I can manipulate the data that way. Manipulating meaning collapse a column I don't want to look at or expand a column I do want to look at.
Okay. You don't change the data. You just are able to view it differently.
That's correct.
Okay. And when you did that, you turned that, of course, over to the prosecutor's office?
I would have submitted that with other reported documents and items to the detectives, which I'm assuming went to the prosecutors at some point.
I'd like to then show you what is marked as Defense Exhibit DF. May I approach the witness, Your Honor? May I approach the witness?
You may.
That's a disc labeled.
Objection to the counsel testifying. There's an improper predicate.
Do you know what that disc is, ma'am?
Actually, I've not ever seen this disc, and that is not my handwriting.
Okay. Do you have with you were asked to bring with you all of your files, correct?
Yes, I was.
Okay. Do you have that portion which we were speaking about with you?
No. This label says Firefox from unallocated space.
She said that's not her handwriting. She's never seen it.
She's identifying the item in her hand, Your Honor. Okay. Do you have the item that we requested that you bring?
I did not work on this particular item. This is what I turned over to Sergeant Stenger.
Okay. And did you put together the Excel spreadsheet that you just testified about? Let me see if I can show you a printed out version. May I approach the witness, Your Honor?
You may. You may.
Does that appear to be a portion of the Excel spreadsheet that you prepared?
I believe this is a document Sergeant Kevin Stinger prepared. If this refers to the deleted Firefox history from the HP computer, this would have been that chunk of space from deleted space with the search hits that Sergeant Stinger and John Bradley worked on.
Okay. Do you recall issuing a report in this case?
Of course.
Okay. On October 20th, do you indicate that you prepared this Excel spreadsheet?
If I could refer to
Yes,
the
please go
report
ahead.
you're referring to.
Sure.
I issued 2 reports in this case. Can you refresh which one you are referring to?
I'm sorry?
Which report were you referring to? There are 2.
Okay. I'm referring to the Firefox header.dat. Oh, which report are you referring to? I believe it's your second report where you indicate summary of findings after August 20th, 2008.
And are you referring to in the middle of the paragraph where it says I exported evidence internet history HP desktop folder as
Correct.
Firefox header.dat?
Yes.
Yes, that's the portion of the deleted Firefox internet history that I copied out and then showed to Sergeant Kevin Stinger, and he worked on it from there. That's correct.
And then you indicate the net analysis report was exported and saved.
That's correct, I did.
Okay. And then do you indicate that it's an indicator that lists the internet history, correct? Why don't you review that portion and tell us what you're indicating there on your report?
Your question's a little vague. This refers to the deleted Firefox internet history where I found the search hit that you asked about.
Correct.
I exported it out of my in-case report where I was working so that my sergeant could copy it to his thumb drive or whatever he copied it to. I can't recall at the moment, so that he could take it back to his machine and work on it.
And then the next paragraph, right there where it says the Excel spreadsheet displays.
Yes.
Okay. What does it display?
My report says it displays in column format the URL page, the file's first access and last access dates and times, an indicator of whether or not the URL was actually typed by the user, and how many times the web page was visited. And then sites visited more than once will display different dates and times in the date and time column.
The list that I gave you, can you read the exhibit number on the back, please?
Identification D Delta F Foxtrot.
I'd like for you to take a look at your screen. Do you see that?
Yes.
Okay. Do you recognize that as the Excel spreadsheet that you recovered from the Firefox unallocated space from the HD desktop computer?
This is in a different format. The printed format and the format you're showing me on the screen is different than the one I would have exported out. The reason I know that is because the columns in this spreadsheet that you're showing today are actually expanded to show all the data inside the columns.
Right.
The one I exported out, the columns are compressed and you have to expand them out.
Okay. But other than them being spread out so you can read what's there, you recognize this, correct?
I recognize some of the content, yes.
Okay. And does this appear to be a fair and accurate representation of that spreadsheet?
As best I can tell, yes, sir.
Okay. Judge, at this time we would move Defense Exhibit H. If I may approach the witness again. Yeah.
What it says to state.
Based on the witness's answer, I would object to the use of this document, she said, as best she can tell, as opposed to having knowledge that this is a fair and accurate copy. She said this was not the one that she prepared.
I believe she...
Sustained, you need to ask a few more questions. It's
Yes.
not certain at this point. You may.
Ms. Osborne, I'm going to show you the original. That was a highlighted, the portions that I wanted to discuss with you. I'm going to actually show you the original that was turned over to us and see if you recognize that. Okay, can you see that?
Yes.
Okay. Does this appear to be the URL, the Excel spreadsheet that was prepared?
I believe Sergeant Stinger prepared this spreadsheet, sir. I don't believe I did this. This does not look like the format I would have prepared the sheet.
So even though your report indicates that this is something you did, you're saying Sergeant Stinger did this?
My report specifically indicates that I found the search hit, I identified the Internet History file, I copied it out to a different location than the computer forensic software I was working in so that it could be saved to a thumb drive and moved to a different computer. The spreadsheet that would have been created, highlighted, manipulated from there would have been Sergeant Stinger's work and not my work.
Okay. But you reviewed this, correct?
No, sir.
You've never seen this before in your life?
I did not work on this document. This is not my document.
Okay, very well. Judge, at this time we have no further questions for this witness.
You need cross-examination.
One question. The HP computer had a password, correct?
Yes, one of the user account profiles did have a password.
All right. It's correct that the owner account or the owner profile had an assigned password of RICO23 that was set on May 14th of 2008, correct?
That's correct.
That's all I have at this point.
You wouldn't have to enter in a password if the computer was left on, would you?
It depends on the settings on the computer. If the computer is set to hibernate or go to sleep or reset itself, then yes, you would after a period of time. But if it's not reset and it just stays open, then any user could log in.
Okay, no further questions. We would excuse the witness subject to recall and ask that she stay, Your Honor.
Ask that she stay here and return to her office.
Stay here. We may recall her shortly.
Okay. Take the bar firm. You may stand down.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Kevin Stenger, Stenger.
You may proceed.
Thank you, sir. Good afternoon, sir.
Good afternoon.
You are a computer forensic examiner.
I am.
And a sergeant with the police department in Orange County.
I am.
Your Honor, I would ask that the witness be recognized as or re-recognized as a computer forensics expert.
No objections from the state?
No objections.
Ladies and gentlemen, he's still an expert witness. You may continue.
Sir, I'd like to direct your attention to the HP desktop computer in this case, and specifically the net analysis report that was conducted. Are you familiar with what I'm talking about?
Yes, sir.
Okay. After the keyword of chloroform was found, you utilized a software called Net Analysis to recover that, did you not?
We used two different programs to do it.
Okay. The first one was Net Analysis?
That's correct.
Okay. And the second one was Cashback?
That's correct.
Okay. The first one was done in August of 2008?
I'm not going to be able to tell you the dates.
Okay. Do you have a report of some kind that might remind you or assist you in refreshing your recollection?
I don't recall being the one that actually did the recovery. I am aware of the search, but I don't recall doing this myself.
Okay. Who would have done the recovery then?
It would have been Detective Osborne.
The woman who just left?
Yes, sir.
Okay. Do you recognize the computer printout on your screen, sir?
Yes, sir.
Okay. What is this that you're looking at?
This is a result of the program when it was run. This would be its printout.
Okay. And are you familiar with this document?
I am.
Okay. Is it a fair and accurate representation of the net analysis report that was run?
Yes, sir.
Okay. At this time, Judge, we would move this item into evidence.
What says the state?
Is it just this page that he is asking him to review, or do we have a hard copy of a document?
I have the disk, and I have it put on here on the screen that I'd like to question the witness about.
Has the witness viewed the entire document?
Can you continue going through the documents, or specifically I'd like to, and I will only be questioning you about the month of March. He's going to scroll down.
Actually marked as an exhibit so we know what we're speaking about.
What's the identification number?
It is marked as an exhibit, Defense Exhibit DD.
Well,
you may. Just a second, we'll go ahead and take care of this other matter. We are taking a recess to 10 minutes to the hour of 4. Thank you. You may be seated. Okay. You need the court reporter?
I believe we're ready, then, Judge.
State, have you looked at the documents?
I have. He indicates he's only going to ultimately be introducing specific pages from those, and he will show them to me as he intends to introduce them.
Well, why don't y'all do that now, because I don't want to send this jury back out again. So look at them and see if you can come to an agreement. You may be seated. Both sides ready to proceed? Yes, sir. Let's return to jury. You may. Okay, state recognized presence of the jury. The defense. You may continue.
Thank you, Your Honor. Sergeant Stenger, have you had an opportunity to review Defense Exhibit DK?
I have.
And is it a fair and accurate representation of a report you prepared?
Yes.
Your Honor, at this time we would move Defense Exhibit DK into evidence.
You may state any objections.
I don't object to the relevant portions of that exhibit being introduced into evidence.
We received an evidence. I assume that the state has looked at the exhibit.
There are tabbed pages that Mr. Bias has indicated to me are all he intends to introduce.
Yes.
And I have no objection to those tabbed pages once they establish their relevance.
And I take it they're untabbed pages.
Yes, sir, and I will not be addressing those. And we can, in fact, take them out, if that makes things a lot easier.
Do you need to take them out?
Yes, sir. Okay. At this time, Judge, we would move that item into evidence. DK.
What it says to state. Be received in evidence as defense exhibit number.
DK will become defense exhibit number 45.
Okay, sir. Let's get a little background on this item of evidence. Can you tell the ladies and gentlemen of the jury what it is?
That is a report of the deleted Firefox internet history using a program called NetAnalysis.
And this is a competing software to the cashback software, is it not?
That is correct.
Okay. And this report was run before you even had the cashback, correct?
That's correct.
Okay. And you met John Bradley at a seminar in December of 2009, correct?
That is correct.
And that would have been after you had completed this report?
That's correct.
And you advised Mr. Bradley that you were having problems with his software, right?
Your Honor, I'm going to object to him leading the witness on direct.
Sustain.
Did you advise Mr. Bradley that you were having problems with his software?
Sustain.
What, if anything, did you discuss with Mr. Bradley?
I asked Mr. Bradley if he could use his tool to examine the internet history that I recovered from unallocated space. And we had encountered a problem with the fact that dates and times were not being displayed correctly across the entire spreadsheet, because the time period that this covers is the time period from when daylight savings time changes. So in the tool that I was using to begin with, when I set the date and time, half of it would be correct and half of it would be incorrect. So I asked Mr. Bradley if he could use his tool, which was reported to be able to compensate for the fact that these records came from the two different time periods.
And so the only real issue that you were having was daylight savings time?
Yes, sir.
Okay. And did the cashback software recover more files or less files from the internet history that the net analysis did?
I couldn't tell you that, sir.
Okay. Do you know if they were identical?
If they were identical?
Yes, the same number of files.
I do not.
Okay. And did Mr. Bradley need some time to fix that issue?
I understand he did.
How many days did it take him to fix it?
It was at least a day.
Okay. Did he have to rewrite his software to make it work?
No, I would object to anything based on hearsay information.
Detective Stinger, is that based upon your personal knowledge or based upon what someone told you, sir?
That would be based on what someone told me, sir.
Objection sustained.
Did you receive a report that you reviewed when utilizing your opinions that he had to rewrite the software?
Objection sustained. Same question.
Very well, Judge. I'd like to approach the witness, if I may.
You may.
Sir, I'd like to direct your attention to March 21st, 2008 at 14:16 hours and 34 seconds. Let me know when you find that.
I found that, sir.
Okay. And that is, what is the website that is addressed with 34 seconds there?
The website is www.sci-spot.com/chemistry/chloroform.htm.
And how many times does it show that that website was visited?
One, sir.
Now I'd like to show you State Evidence 166. May I stand by the witnesses? I only have one copy.
You may.
I'd like to direct your attention to the same website at 15:16 hours and 13 seconds.
Yes, sir.
How many times does it show on the... Well, actually, what is this item?
This item is the report from Cashback.
Okay. And the report from Cashback shows that it was visited how many times?
84.
So there's a difference between the two softwares, is there not?
That is correct.
Okay. And if you can look now at on the net analysis report for 14:16 at 13 seconds, and tell me what website that is.
Within the net analysis report, there are 4 websites that list a date and time of 14:16 at 13 seconds.
The very first one
is www.myspace.com.
And how many times does it show? Does this report actually show whether the item was typed in?
It says typed on the report. That is correct.
Okay. And how many times does it show that that website was visited?
84.
So MySpace was visited 84 times according to the net analysis report.
That's correct.
Can you look at the cashback report and see if that is even on the cashback report?
I do not see an entry around the same time.
Okay. So you don't, on the cashback report, even see a MySpace with 84 entries?
No, sir, not at that time.
Okay. Judge, I'd like to publish this page to the jury so I can demonstrate for them.
You may. Offense exhibit numbered what?
Can Your Honor publish it for the jury for me? I'm having the technical issues again. Okay. So Sergeant Stinger, what you just testified to was that the chemistry, the SciSpot was visited once for chloroform according to the net analysis report, correct?
That is correct.
And that the MySpace, which is just 2 columns down, was visited 84 times. Correct?
Yes, sir.
Now, I'd like to refer you to the time of March 20th, 2008 at 13:39 hours and 23 seconds.
Yes, sir.
Yes, this is.
Show it to counsel. You may.
Okay, sir. Do you see 13:39 and 23 seconds?
I do.
And that is 1 day earlier on March 20th, 2008, correct?
That is correct.
And this is MySpace typed in again, correct?
Yes, sir.
And how many times do you see MySpace the day earlier as being visited?
83.
Okay. So you understand 83 comes before 84, right?
Yes, sir.
Okay. And, of course, July 20th comes before July 21st. I'm sorry. March 20th comes before March 21st.
Yes, sir.
Okay. Now I'd like to direct you to, do not scroll, March 19th, the day before that, at 15:25 with 56 seconds. Let me know when you're right.
The 19th at 15?
Yes.
I don't have any.
I'm sorry, at 8:36 a.m. and 24 seconds. My
8:36:24.
Yes.
Yes, sir.
Do you see the date, March 19th, the day before that? The day before the 20th?
Yes, I see March 19th at 08:36:24.
And do you see where it says it was typed?
Yes, sir.
And that basically means that it was typed into the browser?
Yes, sir.
Okay, and that's the part up top where you write www.myspace.com?
Yes, sir.
Okay. And how many times does it show MySpace was visited then?
82.
Now I'd like to direct your attention to March 13th at 10:37 a.m.
There are no March 13th dates.
I'm sorry?
There are no March 13th dates.
You don't have. Maybe that was one of the untapped. May I approach the witness?
You may.
Show you from mine because I think I'm at. Do you see that it would? Do you see that date on March 13th?
I do.
May I publish this to the jury, Your Honor?
You may.
And do you see, sir, that on March 13th there's an entry that was typed for MySpace 81 times?
That is correct.
Okay. Do you see any indication of any of these MySpaces on that cashback report?
You wouldn't, except for the one date that it has in common. That one cashback report is for the single day only.
Okay. And that report, let me see if I get, just so we're clear, that report only has for the 21st, correct?
Yes, sir.
So you can't see on that report the natural progression of the MySpaces, which starts with it was visited 81 times, 82 times, 83 times, and 84.
That would only have the information from the history that was on the 21st.
And on that report, it does not include the MySpace that was visited 84 times.
That is correct.
And that MySpace that was visited 84 times is just 2 columns down from the Sci Spot, which it says the Sci Spot was visited 84 times.
In the net analysis report, I believe it's 2 columns down, 2 rows down.
Yes. And the cashback program is the one you were having problems with?
No, sir. The net analysis program was the one that was having the problems with the date and time split.
But that was only because it was an hour off.
Objection to the leading. Sustain.
What was it? Because it was just an hour off?
Yes, sir.
Sustain.
What was the reason?
We were having problems with the dates and the times.
Okay. And you don't know if the net analysis report came up with, now you know that the net analysis report came up with more internet history than the cashback did you not? Can you see that now?
The reports are different.
And that report, you prepared the cashback report, right?
I created the cashback report, that's correct.
Okay. The one that's in evidence in this case for this jury to consider, you prepared that report.
That's correct.
But you didn't testify to this jury about that report, did you?
No, sir.
Okay. And this report that was prepared, State's Exhibit 165. May I approach the witness?
You may.
You prepared that report as well, didn't you not, sir?
I did.
And that's the report. What is that, actually?
That is a cashback report for March 17th.
Okay. And you prepared that report?
That is correct.
Okay. It's an item of evidence in this case?
Yes, sir.
And you didn't testify to this jury about the contents of that report either?
That is correct.
Okay. Mr. Bradley did?
It's my understanding he did.
Okay. Do you know the reason why they called in Mr. Bradley to testify about your report?
Objection, Your Honor. Calls for speculation.
Sustained.
If he's aware, Judge?
The witness is not competent to answer that question. Objection sustained.
Yes, sir. If I can have just one moment, Judge.
You may.
Have you ever had another computer expert testify about your reports?
Objection. Relevance.
Sustained.
If I may approach, I just want to recover. I don't believe I have any further questions.
Cross-examination.
Thank you. Detective Stenger, you may have printed out that cashback report, but the data contained in it was collected by Mr. Bradley?
Sustained. Rephrase your question.
How is it that you prepared a cashback generated report? Did you have that software?
Yes.
Okay. And so what process was it that was utilized in order to prepare filtered reports from cashback from March 17th and March 21st of 2008?
I simply set the program up to display only that information from those dates and printed the report.
Okay. The information contained on the report was provided to you by Mr. Bradley?
I actually created the report myself.
The information that goes into the report was nothing that you had worked on, correct?
The program itself, it generated this information.
All right. Why is it then that you had Mr. Bradley look at your data?
I asked Mr. Bradley to examine the data since he was the person who actually wrote software. If I had a question regarding an Apple computer and I had the ability to ask Steve Jobs, who is the creator of Apple Computer, I would have done so. The same thing if I had access to the developer of the program, I would ask the developer of the program if he or she was available to examine it if they were willing to do so. And in this case, Mr. Bradley was.
May I have page 1 of the defense exhibit, the one that was highlighted in green and red, and may I publish that to the jury, Your Honor?
You may, and what's the exhibit number?
What's the last number? Let me first ask the witness, do you see that?
I do now.
Oh, I'm trying to use that to scroll down. Can we scroll up on this to wherever the page in evidence ends? To wherever the page that is in evidence ends. Okay. Do you see displayed on this page that was introduced in evidence any of the Google searches that were conducted on March 21st of 2008?
Approximately 8 rows above is a Google search.
Okay. Are the Google searches for how to make chloroform displayed on this page in evidence presented by the defense?
If you can expand the column H. Right above the MySpace, you will see a Google search specifically for the words how to make chloroform, spelled with an A.
May I publish this to the jury, Your Honor?
Above direct.
Overruled. You may publish.
All right. Since that's been expanded, can you tell the jury what it is that you were just referring to, the how to make chloroform right above the MySpace entry?
When you type a search into Google, you will see the results of the words that you typed in the bar right above when your search returns, and that includes all the words that you actually typed into the search. In this particular instance, the words how to make and chloroform were entered.
Okay. Would it appear that way if somebody typed in a search regarding chlorophyll?
No, it would not.
What is it that you can do in net analysis to determine whether or not the dates and times that appear on net analysis are accurate?
You can simply go in and take a look. Software constantly gets revised, and this would have been several years ago. Since then, changes have been made to different programs that are used. So normally all you do is you go in and you compare the dates in an effort to see if they're accurate or not.
Do you have confidence that the dates and times on this net analysis report are correct? Or would you rely on the report from Cashback as to the date and times for these searches or these entries in the internet history?
The dates and times on these two different reports appear to be accurate. I can't speak to how they were interpreted. by the different programs, since I actually did not write the code
For the,
for either program.
which column on this piece of evidence displays the date and time that this internet history was made?
Can you scroll all the way up to the top of the column?
Here, I'll unpublish that. And does that assist you in
Yes.
refreshing your recollection? Okay, and if we can scroll back to the part
Okay.
that's in evidence. May I republish that?
You may.
Which column would that be? You can use the telestrator if need be.
The first column, 14, 16, 34.
Did I accurately place a box around that?
Yes.
All right. So even in the net analysis, the times between the MySpace.com entry and the next how to make chloroform are 20 seconds apart?
Yes, ma'am.
No other questions, Your Honor.
Redirect on those issues and those issues alone. You may.
The visits for chloroform that are on the net analysis report show that on March 21st of 2008, those were the very first time those websites were visited. Shows only one time, right?
In which report?
For the net analysis report. Can you see that?
I don't have that up on the screen.
May I publish to the jury as well?
What are you going to publish?
The item that's in evidence defense, I believe it's...
What it is, Madam Clerk? Yes, you may.
All of these websites were just visited once.
According to the net analysis report, correct.
And then this right here, maybe the second time. Correct?
Yes, sir.
And the total amount of time spent on those websites, could you look at that and see approximately how much time anyone spent looking at chloroform before moving on?
Approximately 3 minutes.
3 minutes of time. Now, your cashback that doesn't show the MySpace entry, you purchased this after you had purchased the net analysis software?
That's correct.
Okay. And it doesn't have certain items that the net analysis does?
That's correct.
I got to get your cash back.
Sustained.
Now, sir, were there any other issues that you had with the cashback program?
I didn't encounter any problems with the cashback program.
And the only problems that you had with the net analysis was just the time?
That's correct.
No further questions.
Recross.
It's true, is it not, that even if the consecutive entries on an internet history show that those were done in a 3-minute time span, that doesn't negate the fact that the user could just be opening up new tabs in their internet search, correct?
That's correct.
So each of these tabs can be opened for minutes or hours until the person decides to close the tab again, correct?
Correct.
So the fact that these entries are in the internet history shows that they were done in a particular sequence, but tells us nothing about how long that person spent reading whatever was on the web page or whether or not they actually printed that item for subsequent education.
That's correct.
Thank you, Your Honor.
As to that issue,
This report here, does that give you any indication about this tab stuff?
No, sir.
So what was just asked of you, that's pure speculation, is it not? You don't know if that ever happened.
I do not know if that happened.
And you're a sergeant involved in this case, correct?
Yes, sir.
And has anyone ever informed you that through the search warrants or at any time there was any pages recovered that were printed out that has anything to do with chloroform?
Nobody informed me of that.
No further questions.
may the witness be excused.
Yes, sir. Subject to recall.
Thank you, Sergeant. You may be excused, subject to recall.
Thank you, Your Honor.
The defense may call their next witness. Yes. Yes, sir. Okay, ladies and gentlemen of the jury, that concludes the presentation of witnesses for today. We have some legal matters we need to take care of that will expedite things in the morning. Again, have a good evening and abide by all of my previous admonitions. Thank you. You may be seated. All right. Ms. Drain, Ms. Burdick, rather, Mr. Ashton. These next two witnesses.
Yes, sir. This reference to FBI agent Nicholas Savage and evidence control unit, not analyst, but officer Aaron Martin. They're both sitting out there. As to our information, they have no firsthand knowledge of anything. Everything they know is what they were told. So we just request that there be a proffer so that we have a more orderly presentation to the jury and won't be jumping up objecting every 5 minutes. And if their testimony is not admissible, then they can go about their business and go home.
Mr. Mason, will you be conducting the direct of those individuals? Let me hear what they have to say.
Free run of what we're going to do, so they can have the night, I'll be glad to do whatever you want.
Well, they claim I have no reason. I don't know what they're going to testify to. Their state claims is hearsay. I have no idea what they're going to testify to.
Difficulty, I'll clarify for Mr. Mason, if you like. The only thing that Aaron Martin does with the FBI is take in evidence packaged by other people and send it to different parts of the FBI crime laboratory. She doesn't do analysis. She doesn't examine anything. Mm-hmm. So I can but assume that the defense is going to try to get into some aspect of what she was told by someone, since she has absolutely no firsthand knowledge of anything. And so that's why I requested the proffer, because I do believe that my knowledge of her is accurate, and I would ask counsel to proffer what testimony will be.
It's an interesting process that I need to tell them in advance what's coming. Nick Savage is an FBI agent that we have brought to testify about certain activities that he did at the request of the prosecution. And also that Miss Erin Martin from the FBI would testify about what she did in that response. So I'm not talking about one saying what somebody else did. I'm bringing the witnesses that did it.
Judge, and again, there's a question of the relevance of that, because we've already had one experience with counsel trying to get into whether an FBI agent asked somebody to do a paternity test. And the court already ruled that that fact was not relevant, that what the officer asked was not relevant, that what the analyst did was. My concern is that we're going back there again. And I just thought it would be a more orderly presentation if we addressed it outside the presence of the jury. And if the court deems it's admissible, fine. If it deems it's not, then we haven't wasted time jumping up and down and running to the sidebar. That's my suggestion.
Your Honor, it would appear to me that when an FBI agent has memorialized in an email words to the effect, when they're asked about photographs, to construct, in short version and proffer, create a murder weapon with tape, and they respond, we'll just tell them we didn't take the pictures. That's pretty relevant to me, to the entire integrity of this case. I'll be happy to show you the emails now, if you wish.
The integrity of this case isn't on trial. Facts are on trial. The bias and credibility of individual witnesses who have testified is on trial, but the integrity of whatever it is isn't on trial, which is why I requested a proffer. And I would just ask to be called, it be proffered, the court can make an intelligent, informed ruling.
What is your pleasure, Your Honor?
I like to hear it.
You want to hear it now?
I can hear it now. You can hear it 8:30 in the morning, but we're going to start testimony at 9.
Well, let's go for it right now.
Okay.
FBI agent Nick Savage.
Stand here, please. Raise your right hand. Jeff, could you step just inside just for a moment? Thank you.
Answer out loud.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you, sir.
Nicholas, Nickolas, middle initial B, Savage, Savage.
You may proceed, Mr. Mason.
You tell us your name, please, sir.
Yes, sir, Nicholas Savage.
Mr. Savage, are you the lead FBI agent in connection with the investigation in the state of Florida versus Casey Anthony?
I was during my time when I was actually assigned to the Tampa Division and the Orlando Resident Agency.
In general, on the short version, what was your role?
I was the Crimes Against Children coordinator. I was also the Innocent Images case agent, as well as the National Center for the Analysis of Violent Crime coordinator.
Do you recall, sir, whether or not in February of 2009 you attended a meeting with various members of the prosecution team?
I recall being in a meeting where prosecutors were present, yes.
You remember a discussion regarding whether or not it's possible that duct tape could have covered the mouth and nose of this child?
Objection, work product. Discussions with the prosecutors or product.
Mr. Mason? Objection, work product.
I guess it could be. That's a shame. Yes, sir. Okay.
Be sustained under work product.
As a result of your attendance of the meeting, sir, what, if anything, did you do?
Could you be more specific as to what meeting we're referring to?
Pardon?
Could you be more specific as to which meeting you're referring to?
The meeting, well, that we can't identify now. Meeting with the prosecution's team, sir, did you thereafter solicit and try to find some photographs for them?
Yes.
And what, if anything, did you do in order to find those photographs for the prosecution?
I would have coordinated with Karen Cowan, who had day in and day out contact with the lab.
Did you make a specific request for pictures that may have been taken by the Orange County Medical Examiner's Office, specifically photos with scales?
There were questions. Could you repeat the question, please?
Did you make a specific request to locate photographs that may have been taken by the medical examiner's office here?
Possibly, yes.
You remember, sir, requesting of Karen Lowe or Aaron Martin, either of them, for the photographs that should have been taken, showing scale sizes of the duct tape?
There was a request made to the lab, yes.
And do you recall the reason that you asked for that duct tape, those photographs, sir?
I asked for them because I didn't believe that those photographs had been taken up until that point.
Did you receive a responding email from Aaron P. Martin of the FBI?
I don't believe so.
May I approach the witness, Your Honor?
You may.
I want to show you what has been marked.
Counsel, look at the two. This witness is not in the two line on the email. Karen Lowe, Brian Carroll, Elizabeth Fontaine. Yeah. Doesn't reflect Nicholas Savage, this witness.
I'm going to ask him if he's seen the email, and then that's why I've got Aaron Martin here.
Go ahead.
Thank you. We'll show you what's been marked, sir. Exhibit DL for identification asks if you recognize it. Did you receive a copy of this yourself?
The first time I had seen it when it was shown by members from your office. I hadn't seen it prior to that.
And do you recall the circumstances? In other words, does this refresh your recollection of the transaction?
Can I see it again, please?
Take your time.
I don't think the witness has indicated any failure of recollection that needs to be refreshed, so I would object to that.
Overruled. This is a proffer.
Oh, yes, sir.
This is the first time I've seen this email. This is not the one that I looked at earlier.
I'm so close to you, I can't hear you. What did you say?
That is the first time that I've seen that email.
That's all the questions I need of this witness for this proffer, Your Honor.
I don't know if the court wants me to address the admissibility issues now. I don't have any questions for the witness. I don't know what counsel thinks is admissible in that, but I guess I'll wait till maybe after he argues, I'll call the witness back if I need to, but not seeing it.
Well, I'm going to ask Aaron Martin to come in for the proffer.
Okay. The agent may stand down.
Thank you.
Aaron Martin. Yeah.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? That's right, please.
Tell us your name, please, ma'am.
It's Erin Martin, ErinMartin.
How are you employed, ma'am?
I am a request coordinator with the Federal Bureau of Investigations Laboratory.
Do you have recollection regarding the date of February the 6th, 2009, sending an email to Karen Lowe by chance?
Not to my recall. No.
I was wondering how magnificent I approached the bench, Your Honor. Sure.
You may.
And for the record, this is identification exhibit DM. Take a look at that. Tell us if you recall that, ma'am.
Yes.
Would you read it for the court, ma'am, what you sent?
Hey, Karen, I decided not to give the measurements to Nick that Brian emailed us. I'm sorry?
Ma'am, slow it down so the court reporter can take it down.
Of course. Hey, Karen, I decided not to give the measurements to Nick that Brian emailed us since it is part of your case notes and it doesn't appear that the JPEGs were saved. I didn't want to overstep my bounds when it comes to the case notes. I'll just tell Nick that LPOU had no photographs and that TEU has some info on the tape and to discuss it with you. I don't understand why the ME's office didn't take any scaled photos of the tape when it was on the skull. EPM.
And you sent that to Miss Karen Lowe, the FBI.
Correct.
And who is Nick you're referring to?
Special Agent Nick Savage.
The gentleman just walked out past you?
Yes.
And what does LPOU mean?
Latent Print Operations Unit.
And what does TEU mean?
Trace Evidence Unit.
Do you have any other involvement in that process than what you just said in that and read in that email?
I'm sorry, could you rephrase?
Do you have any other involvement in that process other than what you just read in the email you sent back?
In the case?
In this part of the case?
This part of it? No, not with the tape, no.
All right, sir. That's all I have from that witness. Thank you.
Nothing is subject to hearing what the argument is.
Okay.
Recalling her, but at this point, no.
Oh, I didn't.
Would be both relevance and hearsay. And the relevance I don't see, but if counsel will suggest something and I'll argue, but clearly...
Let's take up Mr. Savage first as to the state's objection and the 9401 relevancy. What does Mr. Savage's testimony tend to prove or disprove dealing with a material fact?
A material fact in this case is whether there is or is not, as an example, a murder weapon. Mr. Ashton has tried to create the existence of one by saying that he had a theory that the tape could be a murder weapon and made a specific request to try to get photographs to prove his theory rather than get the evidence and see what it proves itself. And he's asked for those photographs, and he asked Nick Savage, who coordinates it, because all the evidence was sent to the FBI crime lab, and to find it and see if there were photographs with scales on it to show the actual scales measurements as related to the skull, supposedly taken by the medical examiner's office. We've heard conflicting testimony about that. The response he gets back is, in salient points, we'll just say we don't have the pictures. To me, that's pretty outlandish. And, you know, it occurs to me that it's not simply a matter of hiding behind work product, but whether or not it should have been and was in fact produced to us by the bait stamp they're on as potential Brady material. Brady versus Maryland. It's trying to create something. And that's the evidence that catches them trying to create it.
So relevance is an attack upon the prosecution, an allegation that the prosecution has done something wrong.
Not necessarily. I'm sorry.
That's okay. Even if that were true, still wouldn't be admissible because attacks upon counsel are specifically prohibited. I do think that if counsel will read the email more carefully, he will see that this is an attorney in a case, and I appreciate the fact that he thinks that I'm the one that thought of this, and I wasn't, but appreciate the compliment, trying to pursue what evidence is available. I'm hard-pressed to see what counsel would object to that. It would seem that any good attorney representing a client would attempt to explore available information to prove a material fact in a case. But be that as it may, it clearly is not relevant to a material fact in this case, and therefore should be entirely excluded.
Anything else, Mr. Mason?
The prosecutor would like to know if any of you had taken pictures, parenthetic, with scale and parenthetic, of the tape as it was received to show the full length and width of tape pieces before they were separated. They are ESP interested in the width info. They want to know if it would be possible for the tape as it was to cover both the mouth and nose areas. They would need the measurements photos with scale in order to do some computerized recreation images of the skull with tape. The ME's office only took initial photos of tape on the skull without scale, and they didn't measure it because they thought the full measures would be done by us. Would you guys review your notes and give Nick a call on his cell phone with his number? Thanks. Karen will probably speak with you when you're back about requesting some exams on S in the trunk area. And then the response is from the FBI on this very important matter. I decided not to give the measurements to Nick that Brian emailed us, etc. You have that in front of you. No, it's not a matter of attacking a prosecutor. It's a matter of attacking apparently the whole system.
Okay.
We have someone trying to create something that's not there and then saying, I'll just tell Nick that LPOU had no photographs and TEU has some info on the tape and to discuss with you. I don't understand why the ME's office didn't take any scale photos of the tape when it was on the skull.
Florida Statute 90.41 defines relevant evidence. It is defined as evidence tending to prove or disprove a material fact. The defendant in this case, Casey Marie Anthony, has been charged with a 7-count indictment accusing of the crimes of murder in the first degree, aggravated child abuse, aggravated manslaughter, and 4 counts of providing false information to a law enforcement officer. The court, after hearing the testimony of Mr. Savage, finds that that testimony does not go to proving any material issue, in fact, dealing with the 7 counts of the indictment, nor does it go to impeachment on any relevant or material issues. Assuming for the moment this evidence was evidence of an attempt to fabricate evidence, then that would be the subject of a motion to dismiss based upon prosecutorial misconduct, which there is no evidence of that, but assuming you could stretch your imagination to go that far, that would be the subject of a motion to dismiss. This particular evidence does not go to any material issue. In fact, if it goes to any material issues, they are purely collateral issues which have no bearing on either the credibility or believability of any witness. Therefore, the objection will be sustained as to that particular testimony by that witness on that subject matter, which was proffered. All right, the next witness, let me hear arguments about that. I believe Ms. Martin.
The state would make the same arguments. Every bit of information that she has is something that she was told by someone else. Whatever, well, again, I'll just have to wait and see what the relevance argument is before I can address that, because I quite frankly don't see it, unless it's the same one we just heard, in which case my arguments would be the same.
Yes, sir.
I remember the vigorous objections we made, in fact, motion for mistrial regarding the photo image superimposition presented here in this courtroom of the prosecution theory trying to use the tape and over a skull over the child's head, and that's the very issue that this also goes to. They didn't have it. They didn't have medical examiner photographs with scales. They didn't have their own, and that's what has just been established. I'd ask you to reconsider on that basis as well.
I don't believe it's a surprise to anyone in this courtroom that there were no photographs with scale of the three pieces together. I hope counsel will acknowledge having known that for approximately the last 3 years. So I'm not quite sure what counsel's objection is to that.
Court will stand behind this previous ruling. Let's deal with the next witness. Defense has any comments concerning the testimony of the last witness whose testimony was proffered? Again, that particular testimony is not relevant in material, does not tend to prove or disprove any material fact, nor does it goes based upon what was proffered. Again, the evidence does not meet the test under 90.401 dealing with relevant evidence based upon the proffer. Anything else for balance of the day?
Yes, sir.
Oh, yes. Okay.
Pardon? Mr. Baez, Mr. Mason, Ms. Sims.
Just have a nice evening, sir.
I'm going to try to. Court will be in recess. One last thing. Tomorrow you need to tell me and be prepared to go to 2:30, 3 o'clock Saturday. We will break at noon for an hour for a short lunch. Dr. Mason, you look a little bewildered.
Only because I've heard conversations about the logistics problems that would be called for feeding the jury and the judge and so forth.
Feeding who?
The jury.
If there are logistical problems, no one has informed me of any logistical problems. Well, I'm quite sure if they got logistical problems, they will tell me. If not, I will assume there are no problems. We're in recess.